May I get your lordship kind leave to mention one very urgent matter, lordship. It's a tender matter, lordship. What happened? The person who was allotted work order has expressed his unwillingness, and your lordship directed to consider his unwillingness. And thereafter, the petitioner, he was participated in the tender process but could not able to success, lordship. He approached the authority that he was one of the participants to allow him to work, to
What
do
you
the
want?
lordship. Actually, what happened? The person they are going to give the work order as per the version of the CMOE. CMOE is directed a person to be appointed as a new contractor, and superintendent has asked.
Where is your matter?
Lordship, I can leave lordship to move this matter, lordship, on Tuesday or Wednesday, any day, lordship.
Wednesday.
Much obliged.
My lord,
May I be
my lord, may I have your lordship's
permitted to mention item number 612 of today's list, my lord?
612.
612
Yes.
of today's list, my lord. It is just a restoration application. My other side is already there. If your lordship pleases to take it up any time of the day.
Come in the evening after the regular matters are over. Item number 316.
612, my lord.
612.
Similar prayer 522 restoration application. 522.
All your other sides should be notified, not that only one will be there and the others will not be there.
No one appeared in this matter. No one appeared.
Doesn't matter, you still serve notice.
Only dismissed for default.
Yes.
my lord,
My lord, may I mention urgent determination of Justice Biswajit Basu? My lord, I cannot wait till Monday because I am a NCC officer, commissioned NCC officer, senior division, as well as the professor of anthropology, government college. My lord, my transfer is to the unit of NCC, to the college where there is no NCC unit, and 160 cadets of this college would be jeopardized. This has been recognized by the commanding officer of the NCC, also written a note to the higher education department. That is pending. On 18th, I have been directed, that is Monday, to take the release. My lord, there is an urgency, my lord. If your lordship kindly take it up, my lord, I would.
Monday move before the honorable court. It is only for a day.
No,
The
Monday I have
urgent
to take
determination-
release. My lord, I have to take release. Otherwise, it would become infructuous. My
Nothing will become infructuous. The court is in CC and court can take care of it. I'm not bringing matters from that bench.
may I have your lordship kind leave to
The
mention one
determination
matter?
your lordship has today.
It's only for a day. I'm not going
On
to.
Monday, my lord will recall, my lord, this is relating to Howrah Fish Market matter where KMD was, my lord, auctioning the remaining balance for stalls. Your lordship wanted me to come back, my lord, on Thursday. Your lordship wanted this matter to get listed on Thursday. No, that's what the direction was because I had interim application in connection with the writ petition. But unfortunately, the matter is not appearing in the list. My lord, 20th is the last date. My
Was
lord,
any order passed by the court?
no order passed. It's on mentioning, my lord. My lord had indicated that the matter will be appearing in the on Thursday because this is the application day. No, unfortunately, it's not appearing. 20th is the last day.
Within a read old matter.
Yes, yes. I had indicated that to your lordship.
There was no interim order in that.
No interim order.
No interim order.
So the it has to be ordered. If today Thursday it's not appearing, next Thursday file ekhane
But
ache.
next Thursday it will be become day.
This has in fact no connection with the pending matter.
You
That's
say
what I
it
shall
has-
indicate. Lord, that if my lord is
Next
saying
Thursday it will appear. Nothing doing.
Lord, they said that my writ petition will become infructuous.
Nothing will be coming.
Lord, I tell you, lordship, Lord,
Sorry, sir.
Lord,
The
I tell
matter
you,
is
Lord,
not there in the list. I cannot help.
no, the difficulty is not 20th is the matter of auction fixed. Lord, my writ petition is assailing, Lord, because the vacant fish stalls, Lord, were not being granted to me. Now they are being auctioned. So, Lord, my writ petition is directly getting affected. I am blessed by an
You will not be affected. The allotment was made in 1997.
1997. I am a beneficiary of that.
And
I am
he
a
was happy with
beneficiary of that.
allotment. In 2015, he comes and questions.
Lord, I am a
The
beneficiary of
auction
that.
is a fresh auction, and you do not have a interim order
Lord,
for so many years.
1997.
And now
I tell you,
suddenly-
Lord, 1997. No,
I am
1997.
not
Lord,
hearing the matter on minutes.
Lord, that's what exactly what my learned senior friend did.
I am not hearing the matter
Lord,
on
kindly,
minutes.
Lord, it's
Whenever
20,
the matter
before
will appear,
20th, any day, Lord, my Lord, hears out the matter before 20th. Lord, I indicated to your Lordship, Lord, I went before Justice Chatterjee, Lord. He was, Lord, not there. That's why, Lord, I came up before your Lordship. Else, I wouldn't have disturbed your Lordship. Your Lordship wanted me to come back on
some
Thursday.
other honorable judge also has determination.
Yes, my Lord, irrespective of classification, I
Yes.
went there. Because my Lord was not available from Monday, that's why I disturbed your Lordship. Your Lordship wanted the matter to be taken
Now
up on
the
Thursday.
court is there.
Now it's not there, my Lord.
Now also the court is not there.
That's why, my Lord, I'm disturbing your Lordship. Else, I wouldn't have.
File কোথায় আছে? On Monday or not?
Yes,
And whether any requisition was, whether any requisition
Friday.
was forwarded.
Friday.
Please check up.
My lord, yes,
Tuesday, in that case, put it in the list.
my lord, yesterday, my lord,
Obliged.
on my mentioning, your lordship was fixed, my lord, please to fix the matter to appear in the list in Monday, my lord. My lord, I have communicated and I have served notice. After receiving the notice, they have terminated the contract. As I have, my lord, apprehended my apprehension, I have expressed before your lordship. My lord, I will be evicted.
File an application.
Yeah, I'll read petition already filed. My lord, I'll
Affidavit, application,
come with a supplementary affidavit.
whatever is to be done, please do it.
My lord.
My lord,
Yes.
My lord, this matter actually pertains to Jalpaiguri bench, but inadvertently, exclusively due to my fault has been filed here.
So what can be done?
It is to be listed and dismissed. It is not in the list.
Listed and dismissed.
Dismissed for, I mean, because it cannot be taken up here. The determination is with the Jalpaiguri.
Where is the matter? It is not there in the list.
It is not in the list.
To be mentioned.
my lord, may I be permitted to mention a matter, my lord? Lord, I'm praying for upgradation. It was
Not
filed,
today, please.
my lord, it was filed after this monthly list, my lord. It
Yes.
was filed after
Is
this
it there
monthly
in the
list.
list
It
supplementary?
is appearing as item number 241 under new motion 1 other than surfacey matters.
Yes.
My lord, the urgency is that the Aadhaar card of the petitioner that has been cancelled without following due process. And because of the cancellation of Aadhaar, all his financial transactions and the other related activities which are for which Aadhaar registration is essential, he's not being able to do those. And on top of that, he's under police custody. Similarly placed individual had filed a writ petition. During pendency of the writ petition, Aadhaar was deactivated. During pendency, it was again reactivated by the respondent authorities.
So you
And
wait
his-
for the
My lord,
deactivation.
my lord, kindly, if this matter could be upgraded, my lord. I had mentioned this on last occasion.
Budvar.
When,
Serve notice upon the other side.
yes,
Your respondent
241.
should be-
Aajke
Well,
list.
My lord, may I have your lordship's kind leave to
It
mention
is
one
not
matter?
required. Just give the name.
My
Lord,
lord.
may I have your lordship's kind leave to mention one matter, my lord?
Yes.
That advocate on record, my junior is advocate on record in two matters, but these matters relating to virus of West Bengal Act 4 of 2025 was challenged. But those two matters is appearing in the appellate side list, my lord. Item number 1558 and 1559. But yesterday, one matter by Graphics India was moved. Your lordship was pleased to fix the matter for hearing on 7th November 2025. Your lordship was pleased to direct the learned advocate appearing in the original side matters, item number 7, to mention today for hearing these two analogous matter, my lord, along with this original side matter. My junior is there, my lord, who is handing over the slip, my lord. But let this
Item
matter be
numbers. Item
Item
numbers.
number 1558 and 1559, lordship,
Common list.
of the combined
combined
monthly
list.
list.
But let this matter appear is to be mentioned, my lord.
Not to be mentioned. Urgent motion. I will place it on Wednesday. Serve notice upon the other side. The
Deep
learned
blessed.
advocate general is appearing for the state in the other matter. You
Yes.
serve notice.
Lordship, may I
Obliged.
mention
Yes.
one
Deep
matter?
blessed.
Today's daily list of item number 337 of this today's list. My lord, it's a contempt matter, and the last order was passed on 2nd of January 2025, and actually the writ petition was heard on 2023.
What do you want, madam?
Lordship, kindly take it up. My lord, it's an unauthorized construction. My lord, then the petitioner is not able to access the place until unless it is demolish the unauthorized construction.
Who is going to move the matter?
Huh?
Who is going to move the matter? Will you move or somebody else will move?
No. It's on my. I am the advocate on record
You are going to move the matter?
with my senior.
No, with you, not your senior.
All right.
You will move it?
All right.
What
I
is?
have already served the notice to the other side.
Who is your other side? Are you aware?
I already served the notice, my lord.
Not only serving notice, you have to bring your other side with you.
I have served, but
Are you aware who the learned advocate is?
no. This is.
Do you know his or her phone number?
I have already served the notice, but
Go find out. You've got the whole day. I'll take it up in the evening after finishing the regular matters. If you can bring your other side and you are ready, I'll take up your matter. All right. Item number.
Item number 337.
337. Slip is not required. Yes,
Yeah, please permit to mention one contempt application for inclusion.
sorry.
My lord, it's a contempt application, my lord, item number 599, my lord. On the last occasion, my lord had directed that to serve the notice, my lord, but the service has been returned back. First it was written, my lord, refuse, and after it was recorrected, and it is written no such person in this address, my lord. My lord,
Who is the officer?
my lord, the executive engineer, my lord, Borough 4 of KMC, my lord.
Yes.
My lord, the petitioner is a working lady.
I do not want to know the merits, but
No,
first
my lord.
service has to be effected.
Yes, my lord. It is written, my lord, that no such person in that address, but my lord, the petitioner is a working lady. She works in the same borough, and she's telling us that he's working at that same position, my lord.
He's working. All
Yes, my
right.
lord.
Who was the learned advocate who appeared in the writ petition
My
for
lord,
the corporation?
for the corporation, I have to take
Yes.
the order, my lord.
Check up from the order and serve notice upon the learned advocate. All right.
My lord, for
Yes.
inclusion, I have mentioned it before your lordship on 5th of August, my lord. But my lord, your lordship's officer is of the view that it cannot be included without before the monthly list. It can only be included in the monthly list. Now I'm with the urgency ground, my lord. Wetland is getting filled up. Unauthorized construction is being raised. Considering the urgency, the Honorable Chief Justice has converted this matter from the public interest litigation to directly before your lordship as a Group 9 matter. Upon your lordship's direction, the necessary corrections have been made to the.
Give the number, it will appear.
My lord, I'm deeply obliged.
Next Wednesday, as urgent motion, serve notice upon the
My
all
lord,
the other
I
respondents,
shall.
and especially the East Kolkata Wetlands Management Authority.
My lord.
Call the list, please.
Lord, I am for the respondent.
May it please your lordship.
Well, I am taking the point of maintainability. Well, there is disputed question of fact involved and also a money claim.
All right.
Well, that cannot be taken up with the writ petition.
All right.
By preliminary submission would be there is no scope of any interim order.
All right. A lot of submission at the same time. Let me hear the petitioner once.
My lord, before I proceed with the matter, to show that to show my bona fides, kindly see prayer A, which is at page 59. I have already paid.
Was this matter heard by any other bench?
It was released because it did not pertain to that determination. So, my lord, it was released, and my lord, I mentioned it yesterday for inclusion.
Yes, please.
My lord, kindly sees my prayer A. I have prayed for a refund of 25 crores. So 25 crores is lying with the respondent. So, my lord, I am not some dishonest litigant who is wanting to put a spanner in the wheel of the port trust. My lord, where my right crystallizes, my lord, is, my lord, may I just indicate in a nutshell, my lord, what happened? A lease deed was executed for a particular period. That lease expires by efflux of time. Parties mutually continue with the lease by holding over. The last paid rent is rupees 8082 per month. The port trust authorities issues a notice to quit. They file a suit for that, for a money claim. Before notice to quit, they file a suit for money claim. They get a part decree where it is found that the rent is 8082. They get a decree, we pay that, no dispute. Then they issue a notice to quit. They file a suit in respect of that. The suit gets dismissed on the ground that the notice is divorce law. It's
suit for eviction.
Suit for eviction dismissed.
All right.
No appeal preferred. This suit was dismissed in 1982. Nothing done in the meantime. After 23 years, in 2005, they suddenly issue a notice to quit, withdrawing the 1974 notice to quit, which forms the basis of the suit. In 2005, when the notice has already been held to be bad, they issue a notice fresh saying that notice is withdrawn, and we are treating the lease to be subsisting from 1975. Now pay X amount, unilateral increase. We do not pay that. My lord, thereafter they initiate proceedings before the learned estate officer. The estate officer naturally, my lord, passes an order against us. We challenge that before the Alipur Commercial Court by filing the appeal under the public premises eviction of unauthorized. That appeal is allowed. We have been held not to be an unauthorized occupant. The notice has been held to be bad. Their demand has been held to be barred by limitation.
And my lord, we have been held to be in rightful occupation, and that notice is bad.
And
Despite that,
how much were you paying for
my lord,
the
we were
whole-
paying all these amounts without prejudice during the subsistence of my lord, during the subsistence of my lord, the estate officer proceedings, as well as the public premises appeal, which had my lord, gone on for around 10 years. So the court's pleasure was that we should be depositing without prejudice. So
80 something, the
I'm
8,000 rate.
no, their demand was in excess of 1 lakh a month.
No, you are paying 8,000 something.
I was supposed to pay 8,000, but they had demanded huge amounts, which was also the subject matter of challenge. It was ultimately found to be barred by limitation. So nothing. And during the pendency of the appeal also, we had made extra payments. So that is my prayer, A, for refund of 25 crores, which is excess.
Extra means extra
Because the
of
demand
what?
has been held to be barred by limitation.
The 1 lakh rupees demand was held to be bad.
So that my lord, swelled up to 25 crores.
So you paid 1 lakh every month?
Not, they had raised ad hoc demands.
Huh?
The court said pendency of that, without prejudice, we should be paying. So we had paid that. But now, since it has been held that it is barred by limitation, now they do not have any right beyond that 8082. So my claim is for demand, for refund. That is my first prayer. Second is, despite the appeal court coming to a finding that they cannot claim anything excess in excess of 8082, they have now raised a demand of again in excess of 1 lakh per month, which is my subject matter of challenge. I'm led by Mr.
But then all along, the fight was before the suit court. Why has it come before the writ court?
I'm led by Mr. Raymond.
May I, Malad? Mr. Gupta has given the background, Malad. Malad, it wasn't a suit court, Malad, it was the estate officer. Now, Malad,
the last proceeding before the estate officer. Prior to that, commercial court was there.
That was long time back where it was held that I'm holding over, and Malad, the rent was 8,082. Subsequent to this, Malad, they initiate and give a notice, which they they say that was a notice under 106. Malad, we challenged it before the estate officer. Obviously, when the estate officer started the proceedings, and where they also asked for the money, Malad, as a demand on Malad Section 5. Your Lordship knows better than me. So, Malad, on that, Malad, estate officer held, first estate officer held that I'm not holding over, and then held that I'm an unauthorized occupant. From that, Malad, we prefer an appeal. During this appeal provision point, Malad, obviously, Your Lordship knows while filing an appeal, we put on conditions. Now, the conditions were putting in somewhere around 25
thousand per month.
Crores or lakhs.
Oh, crores.
I'm not too sure about that.
All right, some
but
figure.
both are very big for me. Now,
Not for you.
25 crores, Malad.
Not for you.
Now, Malad, 25 crores we had deposited. Malad, that is a separate thing altogether. I've made a Malad, separate claim here, Your Lordship. Malad, now from that appeal, Malad, appeal court holds first, notice is bad. Second, without a proper notice, I still am a holding over tenant at 8,082. And Malad, that Malad, escalated of rent cannot be claimed against me without holding me unauthorized because I am an authorized occupant. Because Malad, the notice has been set aside. Now, Malad, kindly sees. Now,
no unilateral demand using schedule of rate.
Yes, and no unilateral demand using schedule of rate can be made. That was also a finding. Now, Malad, the appeal court passes this order. Malad, according to us till date, we have not found that they have challenged this order. So therefore, Malad, this proceeding has come to an end between both of us. Now, Malad, we have come before Your Lordship, Malad. This is a state authority. Malad, they know that they have suffered an appeal. They know that they are bound by that order. In spite of that, Malad, they are issuing notices for demands which is beyond the lease rental and in contradiction to the judgment of the appeal court. That is why we have come up before Your Lordship as an unfair.
Show me the appeal court's order, please.
Yes, Malad. Malad will kindly come to but it starts from page 192, Malad.
Second.
And there will be 2 volumes, the second volume, Malad. Malad, it starts from 192, 193 is the appeal court order, Malad. But I'll take Your Lordship to the relevant portions, Malad. Malad straight away comes to Malad
First, tell me, this is
Sorry,
under the
ma'am.
Public Premises Unauthorized Occupants Act.
Well, it was under, yes.
Now, but because
No,
does
but-
this bench have determination? I see two
Well, we have
honorable
been going
judges.
round and round, Malad.
Yes, I see. Just now I saw Justice Raja Basu Chaudhary.
Malad, Justice Pasu was of the view, because he has the determination.
Yes.
He is of the view that it is not under public premises. Eviction of unauthorized act, because it is now out of public premises eviction of unauthorized occupants act. So that is why he released it, Malad. That's why you come before Lordship with the residuary now. The first proceeding was wrongly filed
Under-
because we went before the revenue court. I don't think that was the right thing for us.
All right, that is all right. But then Public Premises.
Well, because Malad kindly appreciates, Malad, today what we are saying is that the notice which they have issued cannot be under the Public Premises Act, because Malad, there is an appeal court order and it is in contradiction to the appeal court's order. Therefore, we are saying it's outside, and that's why we are saying it's arbitrary. Or else, Malad, we wouldn't be in a position to challenge.
All right.
Now, Malad, kindly sees, Malad. Kindly comes to, Malad, page 200 first, Malad. Malad, the first paragraph, the underlined portion, thus a lease for manufacturing purposes, even if it continues by holding over, is to be taken as a lease from year to year, terminable only by 6 months notice as stipulated in section 106. Malad, this was what was the ground on which this appeal was allowed primarily, Malad. But I'm just showing the relevant portions, Malad. Malad, kindly then comes to the finding, Malad, straight away, Malad.
Notice that.
Yes, Malad. Now kindly comes to page 201, the third paragraph. The impugned.
Are you seeking for any interim order?
Yes, Malad.
What is
I'm
that?
only seeking, Malad, that the demand notice cannot be given effect to. I'll point out why, Malad. I'll just point out, Malad. Malad, what they are trying to do, first, Malad, that proceeding has been culminated now. So according to that order, Malad, they can only raise it after they give us a proper note. Excuse me, Malad. Notice for eviction. Before that, Malad, they cannot raise such demands. Now what they're going to do, they are issuing these notices, and then, Malad, they will say you are not paying and try and make me unauthorized. That is my point, Malad. Malad, they should at least have some point under which provisions they can issue such notice in the vis-a-vis the or judgment of the appeal court. I'm only on that.
December 24, the order of the appeal court.
Yes, Malad.
The estate officer's order is set aside.
Yes, Malad.
That has attained finality by now because no appeal, nothing of the sort preferred. You are still there.
I'm still there.
They have raised a demand, isn't it?
Malad, they are raising bills. Yes, Malad. Demand.
Bills.
Yes, Malad.
Page 222, I can see one demand notice
Yes,
for
yes, Malad, there are
compensation.
several.
There are several.
249.
All right.
249 onwards.
249 onwards. 222 is also there.
I'm holding over a financial.
Your occupation. After December 24, that means after the order was passed by the appeal court, did you pay any rent?
Malad, we have paid in excess.
So you want
95%
adjustment.
excess. So I want adjustment. But I'll only show 5 paragraphs from the appeal court's order. I think that will suffice, Malad, why I have come before your Lordship. But first, kindly comes to page 208. Well, very quickly, Malad. It shouldn't be taking too much of time, Malad.
Yes.
208. Second paragraph. In view of the discussions made above, I am certain of the conclusion that the KPT's claim for arrears of rent since November 1970 was hopelessly time-barred and hence was incapable of supporting the case of forfeiture on account of default. Malad, this was the same reason why that first proceeding was initiated, that I did not pay, and that is why I have become an unauthorized occupant. So today, Malad, when the demand is there, even if I don't pay, they will again say the same thing. Now, Malad, kindly comes to that page only, Malad, the last paragraph. it is clear from the estate officer's 35th order that the KPT had calculated the rental areas on the basis of schedule of rent charges and not on the basis of the last paid rent at the monthly rent of rupees 8,082.82 inclusive of municipal taxes in terms of the lease deed. So, my lord, the appeal court holds, therefore, my lord, that my last paid rent was 8,082. Then, my lord, kindly comes to page 210, my lord. My lord, the last paragraph, my lord, my lord, the appeal court decides and discusses the law. Kindly takes the last sentence onwards. Thus, the rates or charges, has your lordship got that?
Yes.
Has been imposed upon the respondent company in the form of rent and taxes under the lease which flowed from the Bengal Act of 1890 were to continue under the new Act of 1963, and the schedule subsequently framed under the new law could not have superseded the rate of the last paid rent unless until respondent company's lease could be legally terminated.
Next paragraph.
Then, as the lessor was not given any statutory power to unilaterally escalate the rent, and that too with retrospective effect, clause 14 of the deed did not justify using the schedule of rent in place of the last paid rent while calculating the arrears.
Next paragraph.
As it clearly appears, the rental demand running into close was clearly erroneous, and this error had the effect of robbing the respondent company of statutory right to clear legitimate rental areas so that the ejectment could be stalled. In the light of the discussion made so far, I am of the clear view there was no forfeiture on account of default in payment of rent. Then, my lord, kindly comes to 216, my lord. And the last paragraph.
I can admit.
215, my last paragraph. 216, my lord, first paragraph, sorry. And kindly just after the first 4 lines,
Yes.
but whereas in the present case, man has got that one.
Yes.
The lease was admittedly continuing. The estate officer could not have assumed jurisdiction to invoke the 1971 Act. His assumption of jurisdiction being primed by the finding of unauthorized occupation, no notice under Section 4 could have lawfully originated against a lessee without authority to occupy, was yet to be legally terminated under the 1882 Act. A continuing lessee, as the 1971 Act stipulates, cannot be an unauthorized occupant. And, my lord, accordingly, the appeal was allowed. So, my lord, 5 things. The areas couldn't have been challenged. Unilateral schedule of rate cannot be imposed till, my lord, I am declared as unauthorized. Holding that I am holding over and my lease rent last paid lease was 8,082, my lord. And accordingly, my lord, when this has not been challenged, my lord, and now kindly see the notices, my lord, the demand notice.
Page 249.
Any one of them, my lord, kindly takes page 249.
Before the appeal court,
Yes, my lord.
did you not make any prayer for refund of the excess amount?
No, my lord, that
No
was not.
prayer was-
That was not made. My lord, because, my lord, I'll point out, my lord, this refund, my lord, with humility, I say, my lord, this is a case of restitution. My lord, generally, that is found in the Code of Civil Procedure. My lord, this appeal is under the, my lord, the PP Act references, my lord. The PP Act, my lord, it does not give that provision. So, my lord, whether we should file a suit or a writ, my lord, writ petitions, my lord, your lordship knows better than me. If evidence is not required, my lord, then, my lord, your lordships can also pass such orders, my lord. The amount is admitted. How much is the rent is admitted. And, my lord, therefore, my lord, there is no evidence required in this, my lord, proceeding, my lord. If, my lord, it comes to that, they can file an opposition, obviously. There is a final order, my lord. But this one, my lord, kindly sees 249. Why I am saying this, my lord? Earlier also they did the same thing. That was the finding. That they raised the rate, then said, I'm not paying, forfeit, unauthorized occupant. The same thing, my lord, the same provision, they're starting off again. Kindly sees, my lord, 249.
Yes.
My lord, the heading your lordship will find in the first box, demand notice for compensation for unauthorized use and occupation. So, my lord, kindly sees, my lord, it is absolutely the teeth of the order of the appeal court. And in the bottom, my lord, kindly sees amount. Well, it's the penultimate box, if your lordship sees, description of demand. Has your lordship got them?
Yes.
Free into SOR.
Hmm.
The specific schedule of rate which was told that was not to be used, my lord, invoked unilaterally.
And after the appeal court's order
My lord,
and raising the bills,
my lord.
there was no notice, nothing of the sort
My lord,
from
not
the
to our knowledge. If they can show, my lord, I'll be very grateful, my lord. I do not have any knowledge that whether they have challenged. I have not been issued any, my lord, summons or notices that they have challenged. Second, my lord, till now, even if they challenge, I have not found any stay order of this appeal court, my lord, order, my lord. And third, my lord, if they have got a stay, my lord, I don't know whether they can make further demands, because, my lord, that proceeding has to be first dealt with. Then they can put in this demand if they want to. And, my lord, after that, I don't think, my lord, I've been issued any notice under 106, my lord. I have not, right? We have not received any such notice.
All right, let me hear.
I would be held to be. Well, my reading of the appeal court order is different. Well, what is the case before the appeal court? Well, there, well, we declared them unauthorized occupant and well, charged rent in terms of back rent, means retrospective rent on the basis of SOR. Now, well, what has been struck down by the appeal court is saying that you cannot charge SOR rate on the basis of scale of rate on the retrospectively. You cannot impose that. That is, my lordship will find that. But in the appeal court, nowhere it has been stated that in respect of present rent, you cannot raise bill. Well, kindly have a look. At
Tell me one thing, the appeal court's order has not been challenged.
As yet not. But what is
From
what is
December
not?
till August, it has not been
Not.
challenged.
So,
And you, after the appeal court's order, no notice, nothing of this sort, you straight go on issuing the demand notices.
Not really, because one notice was shown on the basis of 3 into SOR, but other on the basis of present SOR. May I just take your lordship just to the appellate court order and to the notices and say
I think this has to be decided.
decided on
Only
everything,
hearing,
but
yes.
interim order I am opposing. Why, my lord? Kindly grant me 5 minutes, my lord. I will try to satisfy your lordship. My lord, kindly come to page 209. The last paragraph which it has been placed before your lordship.
Yes.
The Major Port Trust Act 1963 had come into force with a effect from such and such. Section 49(1) of the Act gave the authority, gave the right of the authority from time to time, frame from time to time, a scale of rates on payment of which and the statement condition under which any property belonging to or in possession of occupation of the board or place within the limits of port trust used for the purposes of specified hereunder. Neither the Act of 1963 nor such and such which appears to authorize framing of schedule of rent seem to have retrospective effect, and therefore last paid rent in terms of the lease deed was not susceptible to be overridden by schedule of rent. So the appeal court in other words says that you can on the present basis charge on the basis of SOR. And that is the law decided by the Supreme Court as an authority. I don't fix rent. Rent is fixed by an authority, like my lordship knows, CESC, like the Tariff Regulatory Commission. So, like TAM, my lord fixes the tariff. I only issue that. Now, what happens, my lord? He showed one notice. Now, my lord, kindly come to now. What is the issue here, and why he is seeking the interim order from your lordship? My lord, that is very important. My lord, the land in question is 10 bigha of land. 10 bigha. And Malad kindly come to 251 page. Now he is saying, this is Malad looting. Malad kindly come to page 251. They are saying that till date, their rent should be 8,942. Can't be. Now Malad kindly, and they have Malad given that I am supposed to pay. Appeal court never says you cannot charge on the basis of present scale of rent. Now, my lord, kindly come to the present bill. Lordship will find that at page 253. That bill which he said, I am ready and agreeable to withdraw that. Now my lord, kindly come to the present bill, my lord, which has been sent. Now my lord, lordship will find, my lord, the present bill, my lord, lordship will see first bill such, second bill such, my lord, no 3 into SOR charged, lordship will find no damages charged, and the rent is, my lord, is 15 lakhs per month. Now, my lord, the claim of 8,000 basically, a 25 crore basically is, my lord, 8,000 deducted from 15 lakhs and a claim has been lodged. So that is how they are getting the figure of 25 crore. So that is the figure. So I tell your lordship, my lord, now, my lord, here before read court, my lord, if my lord is a money claim. Now, my lord, in the money claim, lordship has to see, my lord, what is the amount paid and what form this dispute is continuing for last 2 decades. Now, for last 2 decades, what should have been his rent in terms of SOR and what he has been paid. My lord, in this situation, my lord, this is my humble submission before your lordship. Can a REIT court go into the jurisdiction, the calculation of last 20 years, whether SOR is that and what is the rent? Should he go before a civil court? My lord, kindly have a look at a judgment reported in 2020, volume 6.
Don't go to the judgment right now.
My lord, it clearly says, 2 paragraphs I just want to show, 2 paragraphs. Where, my lord, is say, if disputed of question of such nature exists, my lord, REIT court should not. My lord, kindly, my lord, allow me. Just 2 paragraphs, my lord. Lordship, kindly have a look at 2020, volume 6, SCC 256. Copy this. Kindly come to paragraph 22. Well, that ABL has been considered in this judgment. Now, my lord, may I place these 2 paragraphs I will place. I will not take much time. 22, my lord, if your lordship.
Yes.
We restate the above position when the petition raises question of fact of complex nature, such as in present case, which may for their determination require oral and documentary evidence to be produced and proved by party concerned, and also because the relief sought in merely for ordering refund of money, here it is done. The High Court should be loath in entertaining such writ petition and instead must relegate the parties to remedy of a civil court. Had it been a case where material facts referred to the writ petition are admitted facts or undisputed, a High Court may be justified in examining the claim of writ petition on its own merit and in accordance with. And last one, paragraph 27. I think I come under the parameter of this judgment completely, man. A priori, we have no hesitation. We have no hesitation in taking the view that in facts of the present case, the High Court should have been loath to entertain the writ petition filed by them and should have delegated to appropriate remedy for adjudication for all contentious issues between the parties. So, I am not over. I have the judgments of 3 judges bench of Supreme Court, which says, scale of rate is the law, is the statute if it is gazetted, and I am entitled.
Where is the dispute?
The dispute is, appeal court's order, he has paid some money, according to the
Paragraph 24.
Paragraph 24, lordship will find. That their claim is in paragraph 24. He has not shown it.
Not only that.
The claim is here. He says, I have deposited extra in terms of order passed by the appeal court or something like that. Now, whatever amount he has said, I am not denying that he has not paid the amount. Now, what is my claim for last 20 years in terms of the SOR? Appeal court said retrospective, you cannot. I cannot. And I admit I cannot. There is no proceeding pending, I cannot. But whatever justified claim, that has to be adjudicated.
Very well. Here, everything is on records. You are a statutory authority.
Lordship.
The payment made by the petitioner, you have the records of it.
Yes, I have.
So, as such, nothing is in dispute. What is to be done is to see what is the SOR, from when it can be made applicable. There are civil courts ordered, the trial courts ordered, and everything is there. Relying on that, you can prepare an opposition and you can come. And the
Well,
Your issue of maintainability, I'll keep it open.
Lordship,
I'll keep it open.
keep it up.
But then according to the appeal court's order, something is paid extra by the petitioner.
Well, I
The
don't know.
one
I have to calculate.
you have to, so it's a matter of calculation.
It's a matter of calculation. For last 20 years, I have to calculate and come up before your lordship.
May prepare a chart, how much you have received,
Lordship,
how much is the SOR,
lordship,
how much is due.
lordship. As of today,
As of today, for you it will be due, for him he says it is extra.
lordship.
So relying on this, the matter can be.
Can be, but Malad, I would say Malad, if Malad, they will say whether SOR applicable, whether it is document is
Do you
correct.
think if you go, if this matter is relegated to the suit court, you will be in an advantageous position? Because I think in the opposite.
Malad, I am not.
You are a
Malad,
government authority.
Lordship.
You need money.
Lordship.
Quantum of land is huge. He is paying only 8,000, you say. It will go to the suit court and will stay there for 28 years. How much will you get?
Lordship, that's also correct.
Then?
That's also correct. Malad, I am not shying away from your lordship's court. Malad, what I
understand.
Just placed before
If you find that there is any dispute, certainly yes, the writ court is not going to enter. But here, if you have records and the figures are not disputed,
No, they are, I think whatever they have paid is not in dispute. I have to just check.
and the schedule of rates is also there. Now, whether the schedule of rates will be applicable, if applicable, from when applicable, this is to be decided.
No, appeal court clearly said I cannot charge retrospectively. But on the basis of present, well, they are occupying in a premises. Now,
I understand it. I can understand your stand. But if the appeal court has said that you cannot charge retrospectively, the amount they have paid previously over and above what you were entitled to, they will be entitled to a refund.
Lordship,
this is their claim.
Lordship, from how, I mean, only one thing. Well, my submission is what is the rent as of today on that day that they have to pay. I am not saying, well, 8,000 when he inducted. Thereafter the SOR, maybe in say 80, it was.
See,
16,000.
79 rent cannot be applicable in 2025. This is for sure. But then what will be the rate and what is to be paid, what is due? Come up with a calculation and finish it off. That will be better for you also, because you will get the money.
Malad, kindly, Malad, do not, Malad, two pairs then I'm making, Malad. For calculation, I need the
You will need time.
I need at least 4
Yes.
time, number one. And number two, Manuel, kindly don't pass any interim order because no proceeding is pending as of today. Malad, I am charging on the basis of section 49 of the Major Port Trust Act, and the bills are being issued. I have showed that. Malad, Lordship, if he has a problem with that bill, I am ready and agreeable to withdraw that bill. But Malad, present.
Which bill will you?
That he said 3 into SOR. Yes, really. Malad, that could not have been done. Phone page 249. That could not have been done. Malad, if it is wrong, it is wrong.
You withdraw in the meantime.
249 we will withdraw.
No, your saying will not do. There has to be something on record that yes, I am withdrawing.
Kindly allow me to come back. I will do that. Malad, that bit is illegal. Malad, I cannot support that.
Please do.
Instruction.
Because this is dated 17th of February 2025, 249.
SOR. That's why I am saying that is a bill which is faulty should not have been issued. Well, I say that. It's not that I am an authority. I cannot take an illegal stand before your lordship. But in respect of other bills, where on the basis of present SOR it has been charged, it cannot be stayed or something like that. Because under statute we are duty bound to issue.
Very well, please come.
May I just reply to the interim order, if your lordship is not minded, madam?
What I am thinking of is that I'll restrain them from taking any coercive step against you and let them come up with the calculations.
This shouldn't be used for a Unauthorized Occupation Act purpose.
Let them come up with calculations and let us see.
Because I have an answer to what he said, but I wouldn't. If your lordship prevents the
if the parties go on with suits and everything, then you will not be able to do business, and they will also be left without any charges.
I don't want to fight with my landlord because I have my workings there.
And you cannot expect 8,000 rupees to be
I'm also-
paid for
But I'm also not
10 bighas of land
I'm not saying
today.
that, my lord. I do not wish to
So-
say that. But my lord, what they are doing, my lord,
8,000 I will pay.
my lord, if this goes to that extent, then I can show why I'm saying it.
No, no.
There is a
There's a
schedule
free
of
fund.
rates which is
My lord,
fixed
it's
by
the
TAMP.
judgment.
Where I am not going to
Yes, so
anything.
my lord,
Please
kindly
come.
prevents them from taking any coercive action under the PP Act. Or else, my lord, I will be without any, my lord, because this cannot be treated as a my lord, failure to pay money.
Well, what massive action we should take now?
আচ্ছা the
আমি গুগলে চেক করে তারপর 10 বিঘাটা ইকুয়াল টু তাই
petitioner is in occupation of
10 বিঘা
certain plots of land of the Shama Prasad Mukherjee port. Stuff. The dispute is with regard to the rent that is payable. Stop. Paragraph. There is an order passed by the Learned Additional District Judge 10th Court Alipur on 2nd December 2024 in PP Appeal number 21 of 2010, wherein the Learned Court allowed the appeal filed by the petitioner on contest by setting aside the impugned final order number 35 passed by the estate officer. Stop. It appears that relying that the order of the appeal court has not been challenged till date. Stop. The Port Authority, on the teeth of the order passed by the appeal court, raised bill on 31st January 2025 on the same rate that was set aside by the appeal court. Stop. Even thereafter, on 28th February 2025, demand for compensation for unauthorized use and occupation of the port trust property within bracket compensation has been raised. Stop. The petitioner submits that the Port Authority cannot treat the petitioner as an unauthorized occupant. Stop. According to the petitioner, the rate at which the demand has been raised is highly excessive. Paragraph. Prayer has been made for passing an interim order restraining the authority from raising any further demand, as there are certain amount which are paid in excess to the Port Authority. Stop. Paragraph. Prayer has also been made for refund of the excess payment which is held by the authority. Stop. Learned advocate representing the port raises a preliminary objection with regard to the maintainability of the writ petition. Stop. It has been submitted that there are several disputed questions of facts which cannot be adjudicated in the writ petition. Stop. The petitioner has raised a money claim in the writ, and because of the disputed facts, the money claim cannot be decided by the writ court. Paragraph. It has been submitted that the petitioner ought to be relegated to the suit court, where the issues can be decided after taking evidence of the parties. Paragraph. Upon hearing the preliminary submissions made on behalf of the parties, it appears that the Port Authority charges rent on the schedule of rates fixed by the Tariff Authority of Major Ports.
TAM.
Stop. The said rate is a fixed one. Stop. The amount paid by the petitioner on account of rent is also on record. Stop. The calculations. Now, there is hardly any scope to dispute the calculations. Stop. What is to be decided is the rate of rent that will be payable by the petitioner and the date from which the same will be payable. Stop. If the figures are properly placed before the court, then there may not be any dispute with regard to the factual issues. Stop. The court accordingly directs the respondents to file an affidavit disclosing the figures and the dates of the rent paid, enhancement of rent, etc. The same may be prepared and circulated. How soon?
4 weeks. Last 20 years calculation.
Today is 14th. Till 18th of September. It will be open for the petitioner to file a reply to the same within a week after the vacation, after reopening of the court after the annual puja vacation. Stop. The matter is directed to appear in the list on 17th November 2025. Stop. For the time being, the respondents are restrained from taking any coercive steps against the petitioner till 28th of November 2025 or until further order, whichever is earlier.
Only one indulgence matter, the point of maintenance.
The point of maintenance, I have recorded that, is kept open.
Time of final hearing.
It's kept open to be decided at the time of final hearing.
Grateful, madam. So grateful.
My lord, I'm for the petitioner, my lord.
My lord, I'm referring for Reserve Bank of India.
My lord, pursuant to the last order, my lord, I have given a representation to the respondent number 4, my lord.
Well,
They
we
have
are considering the representation and we are also taking step, but however, it will take some time. So I will just beseech.
What was your prayer?
My lord, in regard to my lord,
Rectification of civil records, because he has settled this account. However, there were total 30 accounts. While the settlement was done, it was done on the basis of those vehicles, but the vehicles, each vehicle contained 2 contracts. So 15 were marked as settled. However, 15 were kept pending, which affected his civil. So we are taking steps, but my lord, that will take some time. So I will just beseech if my lord keeps it at the end of September before the vacation. By that time, issue will be resolved. My learned friend can also get his relief and we can get this writ disposed of. Any date around 2021.
Please come. Learned advocate for the petitioners submits upon instruction that a detailed representation has been forwarded to the which bank?
Tata Financial Services, respondent number 4.
To the financial institution.
Tata Capital. Tata Capital Limited.
Tata Capital.
Stop next. The learned advocate representing the financial institution seeks time to revert with instruction. So prayer has been made to post the matter after a couple of weeks. Stop. Next. In view of such submission, list the matter on 17th September 2025. Grateful, Judge.
Well, I appear for the petitioner. Well, this is a matter, my lord, where an interim order is expiring on the 14th of August. Lordship's last order was passed on 14th July 2025. This concerns the non-granting of certain concessionary measures which I was entitled to under the Reserve Bank of India circulars. Well, the matter was moved. We were enjoying an interim order. In the meantime, the affidavits are complete. The matter is now ready for hearing. Now, in the meantime, by the first interim order and thereafter subsequent interim orders by a lordship, chance was given to the parties to settle the matter. So we had given proposals. Now, two of those proposals have been rejected. A counter offer, invitation to offer has been given by the bank quoting a particular amount. We've tried to match that amount, and last week we've given another proposal. Well, that is pending consideration. But Lordship, I would not want to stand in the way because we've been enjoying an interim order for quite some time. I would not want to stand in the way. If Lordship wants to hear the matter, I can start the matter. My Lord, we are fully ready. Pleadings have been exchanged. I would maybe only need a short supplementary affidavit just to bring on record these my letter and their letter rejecting it and their counter offer and my counter letter. That's all. Giving the latest proposal only for that purpose. Otherwise, it's ready.
Counter offer is coming from whom?
My Lord, through
South Indian Bank.
Lordship, originally the order which was passed by Honorable Justice Sharkar gave liberty to the parties to settle. So
who are the parties? You
and the South Indian Bank.
South
so
Indian.
we had given two proposals. Those
So
have been rejected.
The Reserve Bank is nowhere involved.
Not.
The guidelines are only by the Reserve Bank.
Lordship, even though they've chosen to file an affidavit to which we filed a reply.
That is different. But then the process of settlement is between you and the South
Indian Bank. Lordship,
I am for the South Indian Bank.
Yes.
Lordship, here is the affidavit in opposition on behalf.
Please give.
Reply have we filed?
What about the settlement? Nothing is happening.
Lordship, as per my instruction, some talk of settlement is going on, and that will take probably some time.
The sooner you finish it up, the better. And since the party is enjoying an interim order, if you feel that you are aggrieved by the same, you can go up in appeal is a different thing. You can get the matter heard at least. Yes. Before any other bench, there are benches having determination to take up matters irrespective of determination and irrespective of years. Why didn't you go over there and get it heard? Because here it's very difficult.
Well,
and
by this way, for your lordship,
by this way, the interim order is being extended from time to time.
Yes, Lordship.
Choice is yours.
Well, if Lordship gives us even 45 minutes, Lordship, I'll conclude my submissions. Well, we want to get it done before.
Please do. Serve a copy.
And Lordship, may I file my affidavit in reply to the affidavit in opposition of the Reserve Bank, Lordship?
And what about your reply to the
Well, I believe that's already been filed on a paper.
On record. Affidavit in opposition by the South Indian Bank Limited is taken on record. Stop. Reply of the petitioner to the affidavit filed by the Reserve Bank of India is also taken on record. Stop. The matter is otherwise ready for hearing. Stop. It has been submitted by the learned advocate representing the petitioners and the South Indian Bank that talks of settlement are going on between the parties. Stop. As the interim order is in existence for quite some time, accordingly, the court is minded to extend the same till 19th December 2025 or until further order, whichever is earlier. Stop. Liberty granted to the parties to take steps for getting the matter heard before any other honorable bench having determination. Pendency of the writ petition will not stand in the way of the parties to settle the matter out of court. Yes.
Grateful, my lord. My lord, is it not possible for my lord to hear the matter, my lord, at all? It wouldn't take too much time, actually, my lord.
I wish. Next.
Grateful, my lord.
Number 2. Madam, it's the matter I am for the petitioner. The certified copy of the deed has not been supplied. It is covered
Yes,
by your
give
lordship.
me the deed number.
Page 16, my lord, the impugned order.
Six 1989.
My lord, may I hand over the report, my lord?
Yes.
My lord. Well, I have some objections, my lord.
You have some objection? Yes, please.
My lord, so far as the deed is concerned, only upon payment of the deficit court fee will not suffice the purpose, my lord, because it's a forged document, my lord.
Yes.
It's absolutely the forged document, my lord. All the deeds were seized by the DO Moishadol, my lord. And a police case has already been initiated, my lord, against the petitioners.
No.
Yes, in the report it is there. And if your lordship kindly sees the report once.
Until the entire issue has been decided by our division bench in the
Yes.
past order.
What is the date of your deed? 6129 I can see. Do you have a copy of the deed?
No, my lord.
You do not have?
No, my lord.
No copy has been supplied till date.
All the deeds were seized, my lord. If your lordship
Yes, I understand.
Seizure list, my lord. It's
And throughout West Bengal, that has been happening.
Yes,
number
I
35,
understand.
my lord. 35, my lord. The deed number is mentioned. Serial number 35, my lord, of the seizure list. 6129, dated 2989. Mine is the last page, my lord.
Last page.
Serial number 35, my lord. 6129.
Dated 20th September.
89, my lord.
It was registered before which authority? Which authority was it registered?
The additional district sub-register.
ADSR?
Yes, my lord, has been served.
পূর্ব মেদিনীপুর?
পূর্ব মেদিনীপুর।
ADSR Sutohata.
Sutahata.
ADSR Sutahata.
Four 465, 467.
725 deeds were seized, my lord, at that point of time.
Yes, yes.
It is still lying with the DO Moishador.
Very well. There is a similar order that has been passed. Show her a copy of the order.
Yes.
Take it down.
Well, were there any police cases pending?
I have supplied only.
Same. It is the same police case. Please take down the number.
No copy has been supplied. Just now I've been given the copy.
Take down, check up WPA 2994, 2494 of 2024. It's order dated 10th of March 25. Srimati Shuhashini Midda versus State of West Bengal and others. Have you seen?
Yes, ma'am.
Check up. The case number is also mentioned. It is the same case. Call the next matter, please.
I'm good.
I'll kindly record my objection, ma'am.
It has been recorded, madam.
Item number 3.
For the respondent number 224.
Ballard, I am for the petition.
Place the case.
Yes, it's effective service upon all the.
Place the case. What is your
sir.
case?
Now, background of the case is like this.
Tell me the prayer. What do you pray?
It is not maintainable, Your Lordship. It's against the private bank.
What is your prayer?
My prayer against the Reserve Bank of India.
Reserve Bank.
Yes,
what has
Reserve Bank of India.
done?
Because the Reserve Bank of India framed the guideline, scheme, integrated banking ombudsman scheme 2021.
Yes.
It was integrated form of 3 ombudsman scheme, 2006, 2018.
Show me your affidavit of service.
I have
your affidavit of service, please show.
Yes, sir. It is not really, but I have effective service communication. They have acknowledged the receipt of the copy.
And the court wants to see the affidavit of service. Show me how have you served?
Yes, sir, by hand.
Let me see. Reserve Bank has been served?
Yes. Axis Bank has been served. Reserve Bank of India also served.
Axis Bank?
Yes.
All right. Axis is there. Then the authorized signatory of Power Home sanction letter. What is this?
Well, let me place the whole pack.
No, sorry, sir. You have to say what your prayer is.
My prayer is against the Reserve Bank of India because Reserve Bank of India has remained silent over the alleged activity of the Axis Bank of India.
What is the activity of the Axis Bank?
Axis Bank has requested us to file a OTS one-time
settlement
proposal.
Plan.
It was sanctioned. Immediately after paying some installment as per the OTS agreement, we have paid due to the serious illness of my mother.
Yes.
Mother.
So where is the Reserve Bank coming in?
We have prayed before the Axis Bank. Kindly extend for 15 days time.
Right.
They have not.
They have not. So whose illegal action are you challenging? The Reserve Bank.
I am challenging the action of RBI because they remain silent. They remain silent for more than April to August.
All right. Thereafter,
we have bound to file this writ petition challenging the inaction on the part of the Reserve Bank because the Reserve Bank of India has framed the guideline.
Yes.
And they have ignored.
Right.
Subsequently, they have decided to close
and
on the basis of clause 10(1)(a).
Now what has happened?
Decision.
Now what has happened? The bank has taken possession.
No, bank is threatening us to take possession every moment.
So
they have invaded our privacy.
You have not paid the money and the bank.
No, I am agreeable to pay money since last year.
Last year, the OTA settlement failed.
OTA settlement failed on account of all my lord.
There was initially an OTA settlement which we had agreed to. They defaulted there. After that, another OTA settlement where they seeked for an extension. We disagreed. And after that, they are again trying to convince us for an.
What is the stage now?
Your Lordship, SURFACE proceedings has been initiated. 13(2) notice has been.
13(4) not yet?
I am not sure, Lordship. Most probably not. Possession has not been taken as per.
All right. So it is the petitioner without a 13(4) cannot challenge it before the DRT also.
Yeah.
Into stage 13(3)(a) stage.
Yes, we have given 13(3)(a).
13(3)(a). How many times will the bank give you time?
No. It was beyond my control. I am a Muslim lady. I cannot pay. It's not productive.
The petitioner.
It's a house building loan.
the
Kindly give
petitioner
some indulgence, otherwise they will
obtain certain loan from the Axis Bank
Limited. Previously,
and defaulted in paying the same. Stop. One-time settlement was prayed for, which the bank
not paid
agreed.
From our instance, we have requested to file a OTS proposal, and accordingly we have filed a OTS proposal. Thereafter, this event
Agreed. Stop. The petitioner defaulted in acting in accordance with the one-time settlement proposal. Stop. Further request was made for one-time settlement when the bank disagreed. Stop. The petitioner submits that direction be given upon the Axis Bank to extend the OTS proposal. Once again, stop paragraph.
Only 15 days was paid for earlier.
It has been brought to the notice of the court by the learned advocate representing the Axis Bank that 13-2 notice has been issued. 13-2 notice under the Surfacy Act has been issued to the petitioner. So, the bank is yet to take possession of the secured asset. Stop paragraph. The court is not minded to interfere in the instant writ petition. Firstly, because the same has been filed against the Axis Bank, which is a private entity. And secondly, because the bank is yet to take any coercive step against the petitioner as on date. Stop. Next, as and when the bank takes steps under the Surfacy Act 13-4 Surfacy Act, it will be open for the petitioner to avail the appropriate remedy in accordance with law if so advised. Writ petition stands dismissed. None appears for the Reserve Bank of India. Notice of the learned advocate dated 10th August 2025 served upon the Deputy Ombudsman, served upon the Reserve Bank of India. Be retained with the records. Return these two. এটা থাকবে ওই দুটো ফেরত যাবে
See some words because since issuance of 13-2 notice, they are regularly taking money from us in various manners. They have attacked our personal liberty and invaded.
Call the next matter, please.
Madam, some protection should be given, madam. Otherwise, item number 4.
Yes, item 4.
My lord, I am for the respondent.
You are for the respondent.
Actually, ma'am,
Very short issue is involved. This my affidavit service.
My lord, this matter, my lord, the
issue is, my lord, that I am the.
my lord, my instructions
service
are, my
provider.
lord, the Indian Oil Corporation has not been served in this matter.
Not
My
been
lord,
served?
it has been served by hand. Kindly see the endorsement. And somebody else is appearing for Union of
No, no. এইটা এই ম্যাটারটা দেখে নি হ্যাঁ হ্যাঁ
But the short issue involved is, my lord, that I am the existing service provider. Now, my lord, a tender has been floated before expiry of my present term. Now, on 21st June, 1st February, this tender was floated. I become the L2 bidder. So I did not object, but the L1 bidder in that tender failed to provide the cars. Therefore, my lord, my tender, my existing tender was extended for 2 months, which will come to an end this month, 21st August. In the meantime, my lord, they floated another tender where the R4 has not participated. Now, my lord, to facilitate the R4, to by whatever manner to facilitate.
Respondent number 4, is anybody appearing? Served?
Yes, my lord, served. Served by DTDC because, my lord, the registered post is not working, my lord. Pit post is not working.
The client had gone and their office was, they did not receive.
My lord, the last page. Last 3 pages. Served by DTDC, not by pit post because that is not working. Now, my lord, to facilitate that respondent number 4, the IOCL is not working upon not opening the financial technical bit. Now they have kept abeyance the second tender just to facilitate the R4. Now, in the meantime, the R4 has procured the cars and they have parked in the vicinity of the IOCL. Now, my lord, my submission is that the government authorities cannot call tenders on their own whims, and, my lord, to facilitate somebody else, they cannot keep this tender in abeyance, my lord.
Show me the document.
Yes, my lord. My lord, kindly come to page 17 first. This is, my lord, the tender where I became L2 and respondent number 4 became L1. Now, my lord, kindly see the description. Custom bid for services such and such number, operation of small vehicles of monthly and day-to-day basis at Haldia Refinery.
1 minute. Page 17 you are showing?
Yes.
Page 17, which portion?
Item category.
My lord, item category.
Item category, yes. Custom bid.
This is the description of the work.
All right.
Now, my lord, kindly come to next. Kindly come to page number 23.
This is floated by the
IOCL. IOCL through the government tendering portal DEM.
No, but then item category is custom bid service, operation of small vehicles of day-to-day basis, Haldia Refinery.
Yes. This is, my lord, for supplying of vehicles for their offices.
IOCL will supply vehicle?
No, the tenderers will supply vehicle to IOCL for movement of the officers and staffs. And CISF staffs.
All right, then.
Now, my lord, kindly come to page number 23. Here, my lord, kindly see L1 Bobita Basumatre, that is the respondent number 4. She has become L1 and I have become L2. I have no objection to that. But the thing is, they failed to provide the vehicles within the due date. So, my lord, what happened, my lord? Kindly see the next page, 24. My initial contract.
Where is the due date?
My lord, that I am coming. Now, my lord, kindly see my initial tender by which I am supplying the car now, that was about to be end on 21st June. So, on 20 June, the next page, they extended my tender for 2 months. Now, my lord, kindly see. Thereafter, my lord, page number 38. Page number 38, they floated a new tender, fresh tender, on 2nd July 2025. Now, my lord, kindly see the description.
The date is on the right hand side.
The date is on the right hand side, my lord, top.
It's 12th of July.
No, my lord, page number 38.
12
of July is our opening date.
Opening date
But
and
floated
2nd
on
July.
2nd July. My lord, kindly see the description. Description is same.
Same.
So, for same work, they have floated a third tender. This tender, this particular tender. So, it is presumed that there is no requirement. Had the respondent number 4 supplied the cars within the due time, what is the purpose of this tender? Same tender.
The technical bids.
And here, my lord, after this tender is floated, the respondent number 4 did not participate in the tender. Now, my lord, the authorities are sitting tight. They are not even opening the technical bids. And my information.
Pursuant to page 38, you participated.
Yes, I participated.
Nobody else is there.
Other participants have also participated.
All right, they have participated.
There
Bid opening date is 12th of July. That is long gone. It has not been opened.
That has been done, but my lord, the financial evaluation and the technical evaluation, nothing is giving effect. They are only
giving effect. They will do it in.
They have not done anything.
They will do it.
But my lord, let them say that they will do. I have no case.
But then why will you file a writ petition
No,
for that?
next page, my lord. Next page, and moreover, my gate pass they have issued till 15th of August.
And where is your right that is being infringed by the authority at this stage?
My lord, my apprehension is that, my lord, kindly see the respondent number 4, page 45. They have already arranged the cars. Therefore, my lord, my apprehension is that they will now page 45 and 46. My lord, they have already arranged the cars,
which is parked within the premises of the IOCL.
My lord, parked within the premises of the IOCL. Now, my lord, the tenderer who failed to supply the cars, now, my lord, by whatever manner they will give them that work order, and my lord, revive the date tender. And this tender, my lord,
this is all your fancy imagination.
Let them say that this tender, the second tender, will be given effect to. I have no case.
They will,
because my lord, kindly appreciate the authorities. They are not owners of public larges. They are only, my lord, holding.
Where is the public largest coming over here?
Yes, my lord, they are only holding that at trust. So, my lord, they cannot, on their whims, today they cannot float.
Please, you are stretching your imagination a bit too far. If I'm not wrong, you'll be able to correct me.
My lord, I'll indicate, my lord, my learned friend did not tell your lordship one vital fact. My lord, this is a tender for providing vehicles for movement within the refinery premises.
All right.
My learned friend's client was the last successful, my lord, tenders 3 years period. My lord, they were there till 2025, from 2022 till 2025. Now, my lord, when their period lapsed, my lord, fresh tender was called for. Admitted position, they were, my lord, L2. And L1, my learned friend did not say that, well, they have a time of 90 days to mobilize the vehicles. Now, my lord, this period of 90 days did not lapse, but my lord, we were writing to them that we are not getting any response because, my lord, we cannot keep any gap in between because the refinery, if it is shut, my lord, it would amount to colossal loss. So we wrote 4 times, we were not getting any reply. Then, my lord, as a matter of abundant caution, we floated another tender because, my lord, tendering process will require its own time. We floated another tender. That is what my learned friend is referring to. And on 2nd of July, only the techno-commercial bids were opened. The price bids were not opened. And, my lord, in the meantime, my lord, they responded that they said our cards are ready because, my lord, 90 days period. Within the 90 days period, the cards, they provided the...
Where is this 90 days period? Show me.
My lord, kindly take, my lord, this is there in all the tender conditions. Even their tender conditions will have it. Special conditions of contract. Your lordship will find, my lord, and this is the standard form contract.
Within which period were the vehicles to be supplied? 14th of bid opening date is 14th March.
12th June is the work order.
Well, 12th June the work order was given. Well, lordship will find right at the top the page, my lord, which is flag marked. 12th June the work order was issued, and my lord, in the special condition, well, and this is there also in their contract also. Any contract, my lord, 3 months time is given for mobilization. And, my lord, this was done because they were not responding. In the meantime, my lord, because it can't be, they admitted position. Their contract is only till the end of this month, 27th or 28th. Now, my lord, when they have deployed the cards and we are confident that they are going to perform, we have decided that we are going to cancel the contract. This is where, my lord, they are aggrieved and they are saying, no, you must continue with this. My lord, when they are admitting that they are L2, my lord, they cannot defeat the right of L1. And 38 number of vehicles, my lord, gate pass has been issued. They have asked for gate pass. Because, my lord, they being the existing contractor, my lord, somehow was trying to prevent any new person from getting in. That is what appears. And, my lord, we have taken it. They don't have any accrued right because the price bid has not even opened. And it's an admitted position that the last contract they were L2.
May I say, Malad, over here, when the contract is given to the successful tenderer, he has to provide within the gap of 3 months the existing vehicles which are not of 2025, which is done in the previous practice. 3 months gap is given for the tenderer to procure the latest vehicle. It is not a case that they will be changing the tender contract.
Listen, you are the L2 bidder.
Yes, my lord.
So if the L1 is
Malad, then
providing
the
the
second one,
vehicles,
Malad, can it be a discretion of the authority? Then they have abandoned it. The second tender was floated.
they will abandon it.
Malad, how can they abandon now? Because we have participated.
You force them. Your right has not even accrued.
Malad, with
in the
respect
second
to
tender.
the second tender, what is the future? Because
It will be abandoned because the first tender will
Malad,
be
how can it be revived now? Because the second tender decision making will only come when the first tender could not be fulfilled by the successful L1.
Well, the tender also has a
It is
clause
not a-
that tender process can be abandoned without assigning any reason thereof. No compensation would be paid.
Malad, on 12th June 2025, the work order was issued. So from that time, that L1 has to put in the vehicles. 3 months is for 2025 vehicles, the latest model.
After they place the vehicles, then you can raise all these issues and everything. And that is
But
between
over
the
here, Malad,
over here,
how
I do
can
not
the
see any of
authority,
your
Malad,
rights.
kindly see,
Please come. Please come.
1.3, Malad, for
The
once,
petitioner.
Malad, for once, 1.3, Lordship, thereafter your Lordship will finally decide.
Yes.
1.3.
Yes.
All the vehicles must be made available to owner within 3 months of award of work order. In case the contract fails to provide 2025, it is restricted. 3 months is given for 2025. Vehicles have to be provided. It is not a stopgap arrangement that you will take the help of others. So you have abandoned the contract. You have forced.
The petitioner participated in a tender floated by Indian Oil Corporation Limited within bracket IOCL on 21st February 2025 for operation of small vehicles of monthly and day-to-day basis at Holdia Refinery for the period 2025-27. The petitioner emerged as the L2 bidder. Stop. The petitioner was already the existing supplier of small vehicles and was given an extension to continue with the work till the end of August 2025. Stuff.
May my lord sleep.
IOCL thereafter floated a further tender on 2nd July 2025, in which the petitioner participated. Stop. The financial bid of the said tender has not been opened till date. Only the techno-commercial bid has been opened. Stop. IOCL did not proceed with the second tender. Stop. The petitioner is apprehensive that the IOCL may scrap the second tender process and will give the contract in favor of the L1 bidder of the earlier tender process. Stop. Prayer has been made to direct IOCL to proceed with the second tender process floated on 2nd July 2025. Paragraph. Learned advocate representing IOCL submits upon instruction that the petitioner admittedly is the L2 bidder in the first tender process. Stop. As the L1 bidder was not responding to the various correspondences made by IOCL for supplying the vehicles, for abundant caution, the second tender was floated. Stop. The commercial, now the financial bid of the second tender has not been opened till date. Stop. After the second tender process was initiated, the L1 bidder in the first tender has provided the vehicles and gate passes have also been issued. Stop. As per the general terms and conditions of the contract, the L1 bidder has 90 days time for mobilization of the vehicles. Stop. The L1 bidder took the 90 days period and placed the vehicles within the stipulated time period. Stop. IOCL intends to enter into a contract with the L1 bidder, and the first bid would be taken to its logical conclusion. Stop. IOCL intends to abandon the second tender floated on 2nd July 2025. Stop. Upon hearing the parties, it appears that right of the petitioner in the second tender has not accrued till date. Stop. Mere participation without finalization of the tender process does not create a right in favor of the bidder. Stop. IOCL, now the petitioner is the L2 bidder in the first tender process. Stop. The L1 bidder has been able to provide the vehicles within the stipulated time period, and IOCL intends to proceed with the L1 bidder. Stop. Accordingly, it does not appear that any of the fundamental rights of the petitioner has been infringed by the authority. Stop. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Service is taken on the go. None appears for the respondent number 4.
Seven, my lord, I am appearing for the petitioner.
I am appearing the state respondents.
My lord, kindly see the page number, page 35. Illegal construction over water body that was intimated to the authority concerned, and Department of Environment, Government of West Bengal already issued notice, page 35. My lord, kindly see for a moment.
Yes.
Page 35 and page 38.
EKWMA, who is appearing? Private respondent, anybody?
No, I am not appearing. The answering will be the municipal commissioner, also Kolkata Municipal Corporation, because they are required, because ultimately they have the power to decide in these issues.
Why?
Isn't it already issue decided? And
1 minute.
Has been given.
1 minute. It must be the EKWMA who is the authority. How is the corporation coming in?
Because within the Kolkata, subject to correction within the municipal areas, that municipality has got now the power to demolish or take steps immediately. Because here in this particular matter, there is a report.
This is a water body.
This is a water body. It's a water body. That is what has been stated over here.
I annexed also the record of rights.
No,
Did you serve the commissioner, Kolkata Municipal Corporation?
I served, but Malad 2 weeks, malad, as the track record is not available, for that reason I unable to obtain the track
Get
record.
hold of Mr. Shapon Devnath. He appears for the Kolkata Municipal Corporation. Right?
Yes.
And
Two mail, malad, I served one notice.
EKWMA, Miss Sinha is appearing, isn't it? Sonal Sinha, in
Sonal
the
Sinha.
other matter, she was appearing. Because the EKWMA possibly is taking steps. EKWMA, you do not appear. Miss Sinha was appearing in the other matter. And she is aware of all facts.
I'll inform, my lord.
All right.
Right now, I'll inform. So that she may be there. Ekটু Sonal ke দেখো না। Sonal Sinha ke। So far as the report of this police authority is concerned, already charge sheet was submitted initially in view of
Charge sheet will not do.
401, but now we have also intimated to the municipal authority, my lord, they should take a decision. We can only implement and extend our police help of
Malad, if you
whatever is required.
Page 32A, the picture of the building. 32A.
4-storied building. Over a water body. Do you have the colored photograph? Page 32A.
My lord, it is not colored photograph of mine, but
Who will say this is a water body? Please come. None appears on behalf of the East Kolkata Metropolitan Development Authority, comma, the Kolkata Municipal Corporation, and the private respondents. Respondent. Stop. Let notice be served upon the non-appearing respondents. Released on next Wednesday.
let the report file be kept in the report.
Yes.
Malad, no further construction, malad.
You obtain report from the DM. Police will not be able to help you out much. All right.
That will do.
Report of the Nadial police station. Officer in charge. Dated 14th August 2025. Is written with the records. Acha likhen in J. The petitioner complains of unauthorized construction by filling up a water body. Stop. It appears that the East Kolkata Management Authority, acha, Chief Technical Officer of the East Kolkata Wetlands Management Authority has already communicated to the Municipal Commissioner of the corporation to take steps for conservation of the water body. ঠিক আছে. Next, learned advocate for the corporation and the Wetlands Management Authority shall come ready with necessary instruction on the adjourned date, 20th. Uri.
I'm grateful.
Grateful now.
Lord, item 8 and 9 are similar. Lord, if my lord takes up 9 first, Lord, and 8 and 9 din 9 ta age din.
We are appearing in 9, 8.
9, who is there? State, congratulations. First appearance before this court for the state.
In item number 8 and 9 also I am for the.
In good hands. State will be in good hands.
Why? The other hands are bad, not good?
I mean,
Then?
now, Lord, my lord knows, Mr. Ganguly, LOC knows the development, or Mr. Ganguly?
I am just in a different island.
He is yet to
Don't
treat
know.
us. He is being
Don't
appointed
know
as one of
anything.
the members of the GST tribunal.
Very good.
He will be adjudicating
Congratulations to
there.
you too.
He will be adjudicating there. Lord, item number 9, why I said so. Lord,
Yes.
before I take your lordship to the pages, I'll be very precise, giving a broader guide, Lord, outline. Lord, this is a tender with regard to engagement, engineering, procurement, construction of solar energy project. Now, Lord, solar panel
Who is
installation.
representing the agency?
Agency ki.
Lordship, I am for the West Lordship.
All right.
Lord, I tell you the word. Lord, in the last 5-7 years,
whatever tender was allotted, no clauses was there that the tenderer or bidder must have a trade license from Bengal, must have a GST license from Bengal, must have a local office in Bengal. Not kindly take the last NIT, because I was the last NIT, I was the L1 bidder, I have done it. Not kindly take note page 49 for a moment. Page 49.
Yes.
October 23 tender, my lords, kindly got that? But kindly come to the eligibility criteria. Take me page 62 first. The general qualification.
Yes.
Lord, my lord, see, kindly see. Bidder, then bidding company, bidding consortium, member of bidding, lead member, bidder must meet eligibility criteria. Then under 7, there are 7 clauses. My lords, kindly got that? Lord, kindly keeping this page, kindly take note page 100 of your lordship's brief. The present tender. Just for a comparison, Lord.
Yes.
General qualification, my lords, kindly got that? Bottom of the page, bidder, meaning of the bidder, then clause C, Roman 7, clause 7, Roman 7. A bidder shall not have conflicts. So then kindly take D and E. D and E was not there in the earlier tender. My lord, may lord verify. I have checked up. Bidder must have local. This is not an essential condition. It's a general condition. It says I must have a local office, a trade license, and a GST license. Now, I can understand GST license for billing. Why they ask for 3 years? If I am L1, I'll get a GST registration from Bengal. But why do I have to have a trade license or a local office for supply and maintenance of a power panel? I have done it on the last time. My lord may see the LOA, page 67 of the last contract. By inserting this clause, they are, my lord, in a way, stopping me from participating in the tender. Lord, these clauses are neither essential clauses. If had it been essential clauses, this would have been part of the qualifying criteria. Qualifying criteria starts, my lord, at page 102 of the present tender. 1.14.4.
The work be executed?
Lord, kindly come to the. I'm so sorry, Lord. I should have shown your lordship that the scope of the work your lordship will get at. Lord, kindly take the present contract. Lord, kindly see page 90. Page 90 is the scope of the work of the present tender.
District covers all within the state
But
of
what
West
they have
Bengal.
done is earlier there was only one contract for the entire state. They said that 200 solar panel will buy. Now in this time they have divided in 5 packages this time, so that, Lord, the financial criteria comes down, and, my lord, some local persons without having the experience can participate. I am not on that. I will compete with them. But in the name of trade license, what is the requirement of a trade license? I am from UP, I am a company. You allowed me last year. I was the L1. Now kindly take the LOA page 67. I have supplied, I am maintaining now, and you don't want me. So you insert that for 3 years I must have a trade license. Kindly come to page 67.
Did you receive your payment for the last work done?
Must have, otherwise they 85% payment has been received. Otherwise, definitely they wouldn't have come and filed a writ petition. Not this way, they are cutting the right. Not the scope of the tender is to get the maximum benefit out of a competitive bidding. You don't want anybody. Now kindly take not 2 more pages of the brief. Not kindly take first page 269. That is 2018 tender, and 250. That is 2019 tender. Same clause. No trade license, no GST, nothing. But kindly come to 250 first. But I have checked, I have verified 254 is the general qualification. No trade license, no license. So it's been very well engineered for the first time. 254, kindly take up. This is 2019. Kindly see the general conditions. My lord will not find anything. And my lord, there is no reasonable nexus. There is no intelligible difference here. Why would you need a trade license?
All right. Yes.
I am a MSME. I have not. I have registrations. Lord, I wrote to them. It is not that I am coming directly to court. Kindly take 234 of the writ petition. I wrote to them. I participated in the pre-bid meeting. I wrote to them 234.
Yes.
Not kindly allow me to place only this portion, 234, point number 2. Concern of the newly introduced eligibility condition. I kindly got that in the middle of the page. Eligibility condition, GST registration, Bengal, existing 3 years, trade license, valid WB license. Our concern, previously never required GST registration in Bengal can be obtained easily before execution, requiring 3-year-old GST registration arbitrary, exclusionary, not a legal necessity for bidding stage, trade license, not for trade license. Trade license are municipal level operational permits that can be acquired post-award. Previously never, not with regard to electricity contractor license, previously never required at bid stage. Solar EPC firms routinely execute works via tie-ups or by obtaining license before commissioning. Then can you turn through the next page? Legal and constitutional grounds, the newly introduced conditions will not mandated in the previous tenders are now acting as barriers to participation for competition. Competent and compliant bidder for outside Bengal, we respectfully submit. Not 1419 quoted, then take 4. Relevant High Court orders have been given. Then 5, our request, modify the eligibility GST registration in Bengal be required prior to the issuance of work order. I don't say I'll not get it. Trade license be obtained before execution. Rest of the previous fair tender now so and so. But kindly see the reply. They modified the tender clause apart from this. Kindly take note, page 233. 233.
And is the bidding period still on?
Till today, the last date of putting my bid. Not 3 p.m. Kindly take 233.
Yes.
233. In a meeting, Maladas Kali got the 29th July, 233.
233 are some drawings I can.
No, 230. 230. Malad is taking up item number 9.
Yes.
Pages are telling.
There is a plan. Some picture.
Pictures, isn't it? Some drawings are there.
Drawing.
আমাকে যা দিয়েছো তাই তো 233. Not a later dated 29 July 2025. 237. Kindly take.
237.
237. Kindly take that.
Yes.
In a meeting, most of the points, not second paragraph, pre-bid meeting, in a meeting, most of the points raised by the bidder have been clarified. However, a number of points could not be resolved in the meeting. The issues have been carefully considered and necessary amendments have been made. Interested bidders may now go through the replies of the queries and also note the amendments as allotted here. Kindly take the next page, the amendment. Kindly see what are the clauses that they amend. 1.14.3.
Very well. Whatever has been amended, amended.
1.14.1 is the general condition that has not been amended. But my submission is there is no reasonable nexus. I already wrote to them that I'll get the GST before doing the job. If I get it, I'll get the trade license. So allow me to participate. That's the only thing I'm paying before your lordships. And the law as has been laid down by the Supreme Court, I'm carrying judgments. If my lord wants me, I can cite that. 2007.
On which point?
On the point, my lord, that kindly take this, my lord. Didn't it? What I'm agitating before your lordships, my lord, on this point only. 2007, kindly take 2007 8 SCC, page 1, para 36 to 39. Para 36 to 39, kindly take.
Yes.
36. We find merit. Got the 36. We find merit in the civil appeal. Standards applied by courts in judicial review must be justified by constitutional principles which govern the proper exercise of public power in a democracy. Article 14 in Constitution embodies the principles of non-discrimination. However, it is not a freestanding provision. It has to be read in conjunction with the right conferred by under Article 21 of the Constitution. The said Article 21 refers to right to life, it includes opportunity. In view of the as held in the latest judgment of the Constitution bench in so-and-so versus so-and-so, Article 21 and 14 are hard to chapter of the fundamental rights. They cover various aspects of life. Level playing field is an important concept. While in construing Article 19(1)(g) of the Constitution, it is the doctrine which is invoked by so-and-so in the present case. When the Article 19(1)(g) confers fundamental right to carry on the business of a company, it is entitled to invoke the said doctrine. We may clarify that this doctrine is, however, subject to public interest. In this world of globalization, competition is important factors and kept in mind. The doctrine is level playing field is an important doctrine which is embodied in Article 19(1) of the Constitution. This is because of the said doctrine provides space which equally places the competitors are allowed to be bid so as to subserve the larger public interest. Globalization is the essence of the liberalization. Today, India has so and so the economic liberalization. Or kindly skip over, kindly take the sentence starts with there. There is one more aspect which needs to be mentioned in the matter of implementation of the aforesaid doctrine level playing field. According to Lord Goldsmith, commitment of rule of law is hard parliamentary. One of the important elements of rule of law is legal certainty. Article 14 applies to government policies. Article 14 applies to government policies if the policy or the act of the government, even in contractual matters, fails to satisfy the test of reasonableness. Then para 39, the Supreme Court interferes. There was a clause inserted by which Reliance could not participate. Para 39, para 38 kindly says, when tenders are invited, the terms and conditions must indicate the legal certainty, norms and benchmark. This legal certainty is an important aspect to rule of law. If there is vagueness or subjectivity in the said norms, it may result in unequal and discriminatory treatment. It may violate the doctrine of level playing field. Lord covers the field, Lord. I only want participation. And I'm ready to get the GST, trade license, whatever they want before, Lord, the job is awarded to me. And I have successfully done the last job. For the first time in 10 years, you are introducing and you need for 3 years. You know that I will not be able to participate. Lord, this is done with a deliberate motive. I pleaded malafide to Lord suit their chosen persons so that Lord the big players cannot participate and Lord they get the tender. I have 2 more judgments. I don't want to multiply. Another one for Lord Supreme Court on the ground of ICDS and the Bombay High Court judgment. But I think this holds the field.
Yes.
This is nothing, first of all, this is nothing malified, Lordship. Actually, is that there's there is no local office in this state Lordship. And my learned federal submission people, just all these depend upon the if and but. If they get, I will allow. But all this for future Lordship. But if they got the GST and got the trade license from the, thereafter they can apply for the new bidder as a new tender. But my learned submission is that if I participate, then I will get, then I will got.
No. His principal point is that he is the continuing operator, right? Now you have inserted this clause for the first time.
First time.
Only to oust him and not to make him participate in the process. What is your submission to that?
That is submission that because in another tender, this is not in the subject matter in this law.
What is the frequency of floating of tenders? Suppose this tender he is not able to participate. When is the next tender going to be floated? How soon are these type of tenders floated?
Within a 6-month Lordship. Within a 6 month, we issue a fresh tender. Because it is not a subject matter, but as per my instruction, that another tender, we face some this type of difficulties. There is no local office, there is some GST. Because if there are no GST, the GST is the state revenue Lordship. So state will lose in the huge tender and the huge project. That's why the huge GST money will be come to the state. There's we face some difficulties in another aspect. That's why we input these clauses in the new bidding form there. There's nothing malified, nothing. But this is my submission. And if they applied for the GST in the West Bengal, if they got the trade license, thereafter they will participate in the new bidder, in the new tender.
Thing is, you are not answering the query of the court. The court is not getting the proper reply from you.
And why for 3 years? 3 years old GST they want.
When was the tender floated? Page 67.
This one. Lord, this one is floated.
Which one? The current one.
Current
which
one is
want to participate.
Wait, 14th July.
14th July.
Page 97, it's 14th of July.
14th July. I made the representation.
Today is 14th of August. 1 month you took to approach the court.
14th July, 24th July, I approached them in the pre-bid meeting. They replied on 31st of July. Then immediately, I came to a Lordship's court. The reply that I have shown, that is of 30th of July, I got, according to my instruction, I got it on 4th of August. I stand correct. Then I came to a Lordship's court. I was not sitting tight, my lord.
Will anybody from the state be able to answer what the court is wanting to know? The scope of judicial review.
Well, I can only answer to this effect. We don't have any instruction. Well, certainly he is there. Well, probably this has been inculcated into this agreement. Maybe that GST, whatever it's collected, is divided between the center 50% and the 50% comes to the state.
I mean,
Now, when he is registered to some other state, then at best, the state of West Bengal may have the interstate GST. It will be another divided into a part. And only that ITC component.
But I'll get the GST right now.
Perhaps this might have, but had it been generated from state only, it would generate directly the 50%. Subject to correction, my lord, that
The petitioner is continuing with the earlier work.
In earlier tender, he was participated and is a
Successful bidder and he is continuing. Are you having any problem?
problem is only this clause, lordship. Otherwise, no problem.
See, you cannot answer the query of the court in this manner. I want a specific answer as to why this has been inserted.
why
Because
3 years
why
is
three-
difficult to explain.
Why 3 years?
This also is very technical aspect.
Kindly allow me to participate.
No, but then you should have taken instructions properly. Today is the last date. It's not that the matter hearing can be adjourned.
Then I will take instruction why the 3 years GST will require that.
When will you take instruction?
Can you make it short possible? Then I will just 5 minutes possible. After 2 p.m. then I will.
2 p.m. I've got other matters. I cannot wait for 2 p.m. I'm passing it over for the time being. You give me a answer as to what will be, why you are keeping this 3 years bracket, and suppose they participate and they obtain it in the meantime, then it will be changing the terms of the bid, because there may be several other participants in the same line of the petitioner who will not get the chance to bid.
Yes.
Do you follow?
Yes, I can follow.
Now that is why we raised it in the pre-bid meeting.
I can follow.
They amended other clauses, not this.
Please get an answer. I'm passing it over. Prior to rising, I will take it.
Yes.
Pass orders.
I'm grateful to you.
Implementation of GST is for the GST purpose only.
10.
State is using the GST.
And my lord, I appear on behalf of the petitioner. My lord, before I start the matter, if your lordship be pleased to recollect, my lord, on Monday, I came rushing before you, this honorable court, seeking some indulgence to get a leave, my lord, for moving it regarding the demolition under the Highways Act, my lord. Your lordship was pleased to grant me leave at 4:30. Immediately thereafter, I communicated. Disregarding the communication of the lawyer's notice, the demolition has been carried out, my lord.
Yes, sir. What was it?
My lord, it's 3 shops.
All right.
The authorities are claiming that I have encroached upon the public road. It's a PWD road, my lord. No, my lord, if your lordship be pleased to refer one.
10-1 order pass, 10-4 appeal also order pass.
Order passed, my lord.
Then you lost 2 forum.
My lord, I'll just indicate. My lord, 2 things I intend to rely upon, my lord. My lord, since I was in a rush, my lord, this is a sketch plan which has been handed over by the BLRO concern, and this forms part of a report which the authority has relied upon. The DM, I'm also serving a copy. Your lordship be pleased to come to the order of the DM, my lord, starts at page 38.
Yes.
My lord, the observation starts at page 41 at the bottom end portion.
Yes.
In the connection, the BLRO, Noida Block, Murshidabad, inquired into the matter and submitted demarcation report pertaining to the government land PWD in front of LR such and such. The plot number is relevant, my lord, I'll indicate why. Under Mouja such and such, that from the inspection report submitted by the BLRO, Murshidabad wide memo number such and such, dated, that is one other relevant, my lord, 11/9/2024, it can be interpolated, and thereafter, immediately thereafter, that the demarcation was made on 18/9/2024. Now, my lord, my first submission is, if a demarcation was conducted on 18/9, that cannot form part of a report supplied by the BLR on 11/9.
Without going into anything, tell me, how are you occupying this land?
My lord, 282 is the plot which belongs to my grandfather, which is adjacent to the highway, my lord. There is an interstate dispute between the legal heirs of my grandfather. There is a suit which has been taken out at my instance, whereby the civil court has been pleased to pass an order of injunction, my lord.
Yes.
That order of injunction is subsisting as on date. If I may rely upon copy of that
Yes,
order.
yes,
also.
yes. Then.
My lord, now one of my relatives, Smriti Pandey, approached this honorable court saying that there is a representation which has been made before the highway authority that they are not considering, and I am occupying over the public road. The portion which is adjacent to the public road is occupied by Smriti Pandey, and that is the subject matter of the civil suit. Now, in furtherance thereof, the honorable court was pleased to pass an order, a representation was made, and the authority comes and determines that I am occupying a portion of the PWD road. My lord, the what portion is very much relevant, because I highlight by, my lord, even the DM has also, if your lordship be pleased to come at page 44, form part of the order, that is the directive of the DM. The assistant engineer Baharampur's highway subdivision, Murshidabad, was directed to remove illegal encroachment and unauthorized construction on PWD government land as disputed in the instant appeal, and the writ petition has mentioned Supra has been encroached by the unauthorized of encroaches, my lord. My lord, the order of the DM under the appeal is limited to the portion to which I am only occupying. That does not give away the leverage, my lord. I'll submit it with the deepest of humility and respect, my lord. That does not give away the leverage. The portion which is not forming part of the PWD road, they cannot ransomly come and demolish the entire structure. What they did, my lord, even in the ground of appeal, where I have made the appeal, my lord, kindly come to page number.
Admittedly, you were occupying portion of the government road.
A portion of the land.
Right. Now, if a construction is there, and for the purpose of demolition of that portion which is occupying or encroaching the government land, if the other structure goes, what can be done?
My lord, two things I have deepest of respect, my lord. Firstly, I have been targeted. It's a targeted killing, if I may use.
Yes.
There are others also.
Your civil suit is pending, whatever right you go and agitate before the civil suit.
My lord, they could have waited. I may
no,
not have been the best case, my lord.
No, sorry.
My lord,
Please
I
come.
have been the best case before your lordship.
Please come.
My lord, demolition was carried on after, my lord, due demarcation of the plot, your lordship.
The petitioner is aggrieved by the steps taken by the state respondents in removal of unauthorized occupants from the public road. Stop paragraph. It appears that the petitioner has lost before the subdivisional officer and also before the district magistrate in the appellate forum. Stop. The fact-finding authorities have come to a conclusion that the petitioner was occupying portion of the government road. Stop. Steps have already been taken for removal of the unauthorized construction. Stop. The court does not find any reason to interfere with the process initiated by the authority for removal of the unauthorized occupants. Stop. The writ petition accordingly fails and is hereby dismissed.
So may I hand over a copy of the report?
Please give.
My lord, just my lord, one more thing, my lord. A notice under the act itself has contemplated to be served. It's a mandate, my lord. My lord, kindly observe that no notice was served, my lord.
No, my lord. Nothing
under
doing.
section
Please go.
24. My lord, and one more indulgence, my lord. If my rights in the civil suit that may not be touched upon by this order, my lord.
Obviously not. It is
My lord,
clear at
because until unless your lordship.
It is made clear that the civil suit interse the parties. Give the number, I can record also.
My lord, the number is, my lord.
TS number something?
33, my lord. 33 of 2024, pending before Baharampur Civil Judge Junior Division, Second Court.
Yes. Is not being adjudicated in the instant proceeding, and the suit will proceed on merits. Yes,
Grateful to your lordship.
Well, I'm appealing for the response.
রাখুন আমি দেখি। Yes.
May it please this court. Madam, this is a case of police inaction. The case is pending for the last 16 years.
Yes.
Madam, there was a dispute by and between the parties. We lodged the complaint before
You
FC.
want early disposal of that or what? Pending for last 16 years. What is your prayer?
Transfer of investigation to the detective department.
No question of my lord. There is a lot.
Oh, I'll hear him first. Yes.
What?
16 years it is
Hare
pending.
Street Police Station, as of today, has become a place of alternate dispute resolution.
All right.
We filed the case in 2009. Subsequently, they filed an FRT saying that this case is civil in nature. We went before the learned magistrate. The learned magistrate was pleased to allow
Reinvestigation.
the reinvestigation, which is not correct. It should have been further investigation.
All right, further investigation.
Against that order, the accused persons came before this honorable court. After the hearing before this honorable court, this honorable court was pleased to dismiss the application and directed that instead of reinvestigation, further investigation be done. Even after that was done, my lord, nothing has happened.
All right. So it's pending.
Since 2022.
After the direction for further investigation, nothing, no result.
And my lord will kindly appreciate that in any investigation, the case diary is the heart of the investigation.
Yes.
Your lordships will kindly pass a direction upon them to produce the case diary, and then, my lord, I will show your lordships how the progress has taken place, if at all it has taken place. The only thing that the investigating officer who I named by name in this petition is asking me to settle the dispute by and between the accused.
What is the dispute?
My lord, it was with regard to
Some
there was a
property?
family dispute by and between the parties. There was transaction by and between the parties, and ultimately they transferred the goods into another company which had a similar name, and they caused us a loss, total loss of 3 crores 11 lakhs 21,207 way back in the year 2007. From then, that dispute is going on. They are asking us to, and my lord, we have specifically written to the Commissioner of Police saying that they are asking us to settle this matter out of court.
All right, let me hear. Yes.
I will kindly ask them to produce the case diary.
Let me hear. Yes.
Well, lordship, kindly see my lord 1, 2, 3, page 3, bottom portion. There is a order passed by this Chief Judicial Magistrate. Against that, my revision application was filed before.
No, these are long ago, 2014.
No, 2022.
Where? I
Revision
can
application, my lordship, kindly see. 2022.
Where 22? I can see 2014 last
My
page.
lord, it was decided on the 17th of.
Page.
My page is, my lord,
3.
This is not paginated. Honorable High Court at Calcutta.
No, page 3.
Oh, page 4. Page 4.
Oh, page 4.
Page 4, lordship, kindly see.
Page 4.
Justice Park has been pleased to pass an order proceeding instant case of state for 8 weeks.
Yes. Subsequently extended finally on 22. Certain priests having considered, I am of the view that it should be directed to continue with the further investigation.
See my last page. I'm not telling you during this stage in between. My lord, lordship, kindly see.
Yes.
There is a settlement. Ramesh Kumar Agarwal, being the petitioner, verbally intimate that his younger brother Suresh Kumar had contacted with him and wanted an informal meeting between the two brothers to resolve the dispute. The petitioner also verbally informed that owing to their brotherly affection and to resolve this long-standing family business dispute, he was willing to sit over to joint discussion with his brother. Police had not taken any part in the discussion between the two brothers. After some days, the petitioner Ramesh Agarwal again approached police and informed that their meeting did not yield a fruitful result. But what police will do? Well, they are saying that the dispute is settled within their brother. Therefore, the officer concerned transferred. Thereafter, my lord, this is the position, my lord. There is no.
Your instruction mentions that the investigation is at the verge of completion and the report will be submitted.
Fix the date
For completion, my lord, let him continue and finish the thing.
My lord, again, if it is challenged before the division.
You cannot say whether it will be challenged or I could challenge or somebody else challenges.
It's not a question of that, my lord. My lord, as for the completion of investigation, my lord, Supreme Court ruling that, my lord, no court can say within this date it has to be completed. That's all.
No, but then from 2009, there has to be an end date.
And my lord, what his report is saying is exactly opposite to my complaint before the CP on the 14th of April 2024, where I specifically complained that this very investigating officer was forcing me to settle the matter.
Lordship can direct the officer, my lord, officer in charge, so and so, that they complete the inquiry proceedings within certain time.
Because Lordship will have to see what he's done, whether he has seized any account, whether he seized any.
No. The merits of the investigation is not the issue over here.
Yes.
So the court is not going to go to that extent. Please come.
Right.
The petitioner is aggrieved by the manner in which investigation is proceeding in respect of the Hare Street Police Station case number 326 dated 3rd June 2009 under sections 403/406/409/418/420/477 caps A IPC. Stuff. The petitioner praised that the investigating officer ought to be changed and the investigation to be relegated to some other authority. Stop. A report, it is the further contention that the police of the Hare Street Police Station is pressurizing the petitioner to enter into an amicable settlement with his brother, against whom the complaint was lodged by the petitioner. Stop paragraph. From the report forwarded by the officer in charge, Hare Street Police Station, dated 10th August 2025, it appears that the investigating officer, SI Soumitra Das, got transferred to another police station, and in compliance with the police station, in compliance with the order of the Joint Commissioner of Police (HQ), order number 44 dated 27th January 2024. Stop. Subsequently, the further investigation of the case was transferred to another officer of the Hare Street Police Station, and the investigation is at the verge of completion, and report in final form shall be submitted before the learned court shortly. Stop. Paragraph. Surprisingly, the officer in charge, for reasons best known, has not disclosed the name of the police officer presently investigating the subject case. Stop. The name of the officer who got the name of the erstwhile investigating officer who got transfer has been named, but the current officer has not been named in the report. Stop. Next. The investigation is admittedly, not investigation, the complaint was admittedly lodged in June 2009, and even in the mid of August 2025, investigation is yet to be over. Stop. The delay in concluding the investigation is certainly a matter of concern. Stop paragraph. The court is accordingly constrained to direct the Deputy Commissioner of Police within brackets Central to oversee the process of investigation and ensure that the same is concluded at the earliest without any further delay. Stop. The writ petition stands disposed of.
Just
Lordship, one line, my lord. Due to, my lord, stay order passed by this court, my lord, we cannot.
Whatever is there on record is record. Stay order was for only six weeks or something. Yes, but from 2009, no explanation.
A report kept on.
Yes, report is on record. Can it use?
Direction of this honorable court, my lord.
Yes.
Certain documents, my lord,
Yes.
certain documents, my lord, I am required to furnish, my lord, by management, my lord. My lord, today I am furnishing the death certificate and other related documents which he has asked for.
ইয়ার ভুল ছিল।
Postmortem, এই যে এখানে আছে। এর মধ্যে আছে না এর মধ্যে আছে এর মধ্যে সব আছে না এগুলো আছে
On 4th January 2023, the petitioner got information from the Dom Central Jail that her husband died during incarceration, my lord. And my lord, she applied for death certificate, then PM report and medical documents.
These are all the documents.
My lord, she hasn't get that.
Let me see.
It's a sealed, my lord.
Open it.
Sealed document. এই টুটা এগুলো তো দিতে হবে এগুলো তো দিতে হবে এই টু দিতে হবে তো এই ওয়ানটা দিতে হবে কোথায় রিপোর্ট এটাও দিতে হবে তো কেন এটাও না সব আছে সব ওখানে তো অরিজিনাল
You want the death certificate and the PM report?
PM reports and the medical reports, my lord.
Medical reports, death certificate. দেখি
কেন এগুলো তো আছে এই টু A3 A4 কোথায় আছে সব ওখানে আছে ওটা দিয়ে দিও তাকে কিছু ডেথ পেপার হ্যাঁ তাই তো আমি বললাম বাকিগুলো তো এখানে আছে other reports I have handed over.
Other reports means the PM report is here.
PM report, death certificate and
this is a death certification. This is not the death certificate. Death certificate has to be obtained from the corporation or the municipality, wherever the jurisdiction is.
Yes. And medical report and other documents, I have just now I have handed over to her.
You've given?
Yes, yes.
All right. And I would like to hand this over to the petitioner.
This is
all right.
Yes.
This is original.
Yes.
I will retain the photocopy and hand over the original to the petitioner.
Yes, yes.
Because she will require this for further processing. Please come.
Yes, yes. Definitely not.
Learned counsel representing the state has produced before this court the postmortem report in original signed by 3 medical officers of the Arjikar Medical College. Countersigned by the Arjikar Medical College Police Morgue. Dated 5th January 2023. In connection with Tala PS inquest number 23 and UD case number 16, dated 4th January 2023. ঠিক আছে? A receipt under the nomenclature death certification of one Laltu Ghosh, son of Ananta Ghosh, signed by the emergency medical officer of Arjikar Medical College and Hospital. কি বললাম? Signed by এত has been আগেই বললাম না handed over, একদম গোড়ায় কি দিয়ে শুরু করেছিলাম, learned counsel have produced before this court, ওইটা ঠিক আছে। The originals produced তো উপরে বলেই দিয়েছে। Oh, তাহলে has also been produced in a sealed cover, ঠিক আছে। The originals will be required by the petitioner for processing further claim in respect of her deceased husband. Stop. The originals are accordingly handed over to the learned advocate representing the petitioner. Stop. Copy of the same are retained with the records. ঠিক আছে জানা বাবু, এটার জেরক্স হবে। Go through this. I am keeping it one more day. You come back. If you intend to say anything, then you can make submission.
No, my lord, I will take it.
No, other
Alright.
documents I have handed over to you.
Achha. What are the other medical documents that you have received today?
The other medical documents, my lord, there's a report, my lord.
Report of the medical officer, my lord, and my lord, also my lord, photocopy of the postmortem report also is.
Oh, if the photocopy is there, then
Photocopy is there, my lord.
Yes.
is already there.
Yes, all the relevant documents are there, my lord.
Achha. A bunch of documents containing the medical documents of the petitioner husband of the petitioner has been handed over by the learned counsel for the state to the learned advocate for the petitioner in court today. Stop. Release the matter on Monday. I am keeping it under the heading to be mentioned.
Great.
For disposal.
No, Lord, shall I hand over the photocopies which I have handed over to her?
Please do.
Please
That
pick
will
it.
be good. Yes. If it is here, তাহলে তো আর দরকার পড়বে না।
Yes.
Is the
All the
certification
documents.
here?
If you lordship value, takes my lord. First, my lord.
Where is the death certification? That slip is not here.
Not here.
Death certification is there, my lord.
The
It is not here.
আপনি এটার একটা দুটোরই জেরক্স করি ওনাকে দিয়ে সই করিয়ে রাখবেন।
PM report is also here, my lord.
All right. এইটারও একটা কপি রেখে দেবেন। For disposal. Next.
My lord, I am for the petitioner led by Mr. Shobushadi Chatterjee. My lord, I am praying for not today due to he was present in the court at today morning, but due to some personal difficulty has left the court. He is not present in this court at this moment.
Why did you not take instruction? These urgent motions can be disposed of, and this is the reason it is here.
My lord, on the last day, your lordship wanted to dispose of this application.
Yes, see?
Insurance ombudsman, my lord, against an order of insurance ombudsman, my lord.
Yes.
My learned friend has come up. Your lordship wanted to dispose it off
Right.
with the liberty to go before the appropriate forum, my lord.
Absolutely.
And your lordship wanted to see, my lord, the rules of ombudsman,
Yes,
my lord, that
yes.
it is not binding upon the petitioner, this order of ombudsman.
All right.
17.8, my lord. That was the only point, my lord.
Dekhi.
Rule 17.8, my lord. It is binding upon the insurer. That is what it says, my lord.
17?
8, subsection 8, my lord.
8.
Sub-rule 8. Rule 17, sub-rule 8. 17, my lord, is the award passed by the ombudsman, and sub-rule 8 says, my lord, the award of insurance reimbursement shall be binding upon the insurers only, my lord. It's insurers. It is not binding upon the writ petitioner, my lord.
What remains in the writ petition?
Order which is not binding on.
He wants to set aside the order of ombudsman which is not binding upon him.
What to do?
Well, kindly not today, on Monday, my lord.
Acha, on the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned for the day. Our actor line likhe din, learned advocate for the IRDAI
Respondent number 2
has relied upon the notification dated 25th April 2017 by the Ministry of Finance, Department of Financial Services, within bracket Insurance Division, which clearly mentions in clause 17 within bracket 8 that the award of the insurance ombudsman, IO caps, shall be binding on the insurers. Next.
Grateful, your lordship.
Did I appear for the state respondent?
My lord, I am appearing for the Metro Railways.
In favor of the petitioner. Take steps for recommending the name of the.
Your lordship, I am led by Mr. Chaudhary. I am appearing for Kolkata Metro.
May I hand
My lord,
over?
it has been paid, I am told, my lord.
You are happy? All right, please come.
My lord, one request, my lord, that this should not be treated as a precedent, my lord, because otherwise there may have been some technical issues which we, my lord, overlooked.
As and when issues come up, we will try to resolve. But I am not writing what you want the court to write. All right. The grievance of the petitioner. Now, the petitioner submits that his grievance has been redressed by the authority. Stuff. In view of such submission, there is no requirement of proceeding with the writ petition any further.
Yes.
The writ petition stands disposed of. Be it recorded that where is the figure mentioned? Is anything mentioned? How much did you receive?
5 lakhs. 5 lakhs.
A sum of rupees 5 lakh has already been disbursed in favor of the petitioner. All right, next. Thank you, Mr. Chaudhary.
No, grateful to your lordship, my lord.
Should be kept on record, my lord.
What thing?
The letter of recommendation, my lord.
All right. Whatever you have given, everything will be on records.
I'm good, my lord.
একটু রেখে দেবেন তো কি দিচ্ছে?
একটা কপি আমাকে দিলে হ্যাঁ এটা কপি আমাকে ফোন করেছিল
Next.
My lord, I appear on behalf of the petitioner, my lord. In this matter, my lord, my client wanted a rehearing, my lord, before the appellate authority. There is a violation of the principles of natural justice, my lord. This is the appellate forum of the RBI, my lord. Will kindly see the order before the RBI. Lordship, passed an order on 7th January 21. We were served. We preferred an appeal on 10th February, my lord. The appeal papers are at page 149. My lord, the appellate forum did not give any date. We wrote letters to fix a date for hearing. Upon receipt of our email, my lord, they fixed a date for hearing. On 15 December, we were communicated that on VC, on video conferencing, the hearing will take place. We wrote on 15 December itself, within a span of 2 hours, that there's a technical glitch. We could not present our case. Mrs. Geeta Chaudhary, my lord, that will kindly come at page, my lord, 193, my lord, page 193, we requested for a rehearing, my lord. And thereafter, we gave 2 reminders. Instead of fixing a date for rehearing, my lord, they communicated a copy of the order rejecting our appeal, my lord, without giving us a hearing.
Lordship, my instructions are, Lordship, they are not admitting the technical glitch. It is said that they could not feel any technical glitch during the hearing which could have impacted the decisions. That is my instructions. Lordship.
My lord, all we want is a
Therefore,
rehearing. They may pass the same order, but we just want a rehearing, my lord. The appellate forum will consider our points and pass an order, my lord.
Otherwise,
my lord will kindly come to
Tell
page
me one thing. I am not very acquaintance. I do not have acquaintance with these technical issues. But if there is a glitch at the side of the petitioner, will the authority be able to identify it? From your side,
because that was the
from your
instruction.
side, maybe there was no glitch. But whether there was any glitch from the petitioner's side,
that, I mean, we could not feel any glitch that had impacted the hearing. That is my instruction.
I understand. Admittedly, the petitioner could not appear on the 15th of December and the award was passed on the 17th of April.
He had
So,
appeared, Lordship.
you had 4 months' time. What would have been different had one opportunity been granted to the petitioner? I'm just thinking aloud.
Lordship, that I leave because your Lordships had asked me to take instructions
yes.
regarding the glitch.
Right.
So my instructions are there were no glitches. I mean, they didn't realize that the petitioner was not there. I mean, that is
Maybe the
impression.
petitioner deliberately creating this glitch.
Maybe. Lordship, that I leave it to your Lordship.
But then since I see from December till April, you could wait. And in January, there were requests for giving a hearing, which was not considered. 4 months you could wait and you could not give one more hearing.
Lordship, that is because we had passed the order, but in again a hearing, Lordship, once a hearing is complete,
What
it's very
is
difficult
exactly
for
the
us.
order?
Lordship, that the Lordship,
my lord, we had applied for a non-banking financial corporation certificate from RBI. That was rejected, my lord. NBFC certificate we applied. We preferred an appeal. The appellate authority, my lord, we only want a hearing before the appellate authority. They consider our points. My lord, the order is dated 17th April, my lord. The order is dated 17th April.
Now 23 to 25, 2 years have already elapsed.
That is...
My lord,
you file the writ petition, you get the order in April 23 and you file the writ petition in July 24. Why? Why so much of delay?
My lord.
What is your explanation?
My lord, our clients were contemplating, my lord, whether to pursue or not. My lord,
this is, I do not see the bona fide intention.
They wanted to file an appeal, my lord. They wanted to file.
Had they wanted to file an appeal, then immediately after April, they could have come. They waited till July 24, more than a year.
Please no, my lord, we have only one rehearing, my lord. Only rehearing, my lord. One day that will take to the appellate authority, my lord.
Petitioner.
Only one rehearing, my lord. My lord, we had
the
requested
petitioners
in December. The order was
are
passed
aggrieved
in April,
by the order passed by the appellate authority in dismissing the petitioner's appeal by passing order dated 17th April 2023. Stop. Submission of the petitioners is that hearing was conducted through video conference mode on 15th December 2022. Stop. Due to technical glitches, the petitioners could not participate in the hearing. Stop. Request was given for providing fresh opportunity of hearing, which the authority refused and passed final order on 17th April 23. Prayer has been made to set aside the order of the appellate authority and remand the matter back to the appellate authority for fresh hearing. Stop. Paragraph. Learned advocate representing the union.
And respondent number 1 and 4. Lord.
The respondent numbers 1 and 4 submits upon instruction that the authorities could not identify any technical glitches at the time of hearing. Stop. Paragraph. On a perusal of the documents of the writ petition, it appears that the order impugned is dated 17th April 23. Stop. The writ petition was filed on 11th of July 2024. Stop. Had the petitioners been genuinely aggrieved by the order passed by the authority, they ought to have approached the court immediately after the order was passed, or at least soon thereafter. Stop. The petitioners waited for more than
My lord will kindly not
15 months
the authority waited for
to
4 months.
approach the court. Stop. There is no explanation for the delay in approaching the court. Stop. The court is not convinced with the stand of the petitioners.
Lord, my business will come to a halt, my lord. Only one hearing, my lord.
In not appearing before the appellate authority on the day fixed, and also not approaching this court in proper time. Next, in view of the above, no relief can be granted to the petitioners in the instant case. The writ petition fails and is hereby dismissed.
My lord will kindly consider, my lord, 4 months they waited, my lord, to pass an order. Only one date, my lord. My learned friend will fix it tomorrow, my lord. They can fix it tomorrow and dispose it of, my lord. Only one hearing, my lord.
Item number 5, fixed at 153.
Is the petitioner there?
Yes, yes.
Yes. Dispose it of? No? Nothing doing?
I'll be seeking for another.
What?
Kindly send her to some other
Sorry.
verification.
I am sorry.
Well, this was
No.
Kindly hear me. Well, this was the prescription was handed up to her on that day by the SSKM doctors. Now kindly have a look.
The medical board is from the SSKM. It's not from somewhere else. Will the court go over and above the consensus arrived at 11 doctors?
Army hospital.
Sorry, sir.
To have the cross check. Kindly
Nothing. Why will I disbelieve?
Have a look.
Why will I disbelieve 11 doctors of the hospital?
That's why I'm giving up.
What you are giving?
Kindly see. This is the prescription of her. On that date, 12th August.
Second page.
What to see from here?
On top, we'll find at High Court of Calcutta WPA number such and such.
Yes. Yes.
On the left hand side, visit date 12th August 2025.
Yes.
Yes. Now, kindly come to the next page, second page. Manad is looking at one. Can I see this? This is the one.
This is the first page.
Yes. Yes.
Turn it over second page.
Kindly come to the second page.
Yes.
No, I'm not placing that part. Kindly read the last portion.
What?
She says she was told that yes, we can go for it.
You please carry it up in appeal. I am not believing anything else apart from what the 11 doctors have said. Please come.
And for her satisfaction,
no, not satisfaction. There must be a limit. The court is on The cameras are on. I am not uttering a single word.
That I can.
I am restraining myself. I am not uttering a single word. There must be a limit. Will you please tell me if there was a direction for her to report to the medical board? What was the requirement of her to go over there and get all these things done?
No, on that very same day, this was handed up to her. That's what I am being told.
Will you believe this, or will you believe the report of the
Definitely.
11 doctors' unanimous opinion? Actually, the learned advocate representing the petitioner produces a photocopy. Do you have the original of this? Photocopy of
They are having.
Of the OPD ticket of the petitioner of the before the SSKM hospital on 12th August 2025. Stop. The learned advocate for the petitioner submits that there is that the petitioner was counseled about the outcome of the termination if attempted at this stage, and the procedure for termination, which will resemble a mini labor. Prayer has been made to get the petitioner cross-checked by a separate medical board. The court has perused the report of the medical board of the hospital consisting of 11 doctors. The court has perused the unanimous recommendation of the board of 11 doctors. The court is not at all convinced to accept the prayer of the petitioner for permitting her to be checked by a separate medical board. The prayer of the petitioner for termination of pregnancy cannot be allowed. The writ petition fails and is hereby dismissed.
Even under the Act, up to 12 weeks.
Nothing, no submission.
No,
No submission. Pass over.
Item number 4, pass over matter. Item number 4.
ওর আছে বলুন সেটা ফোর আছে ফোর আছে
This will be the last matter before recess, so others can leave. Otherwise, you will say the advocates have been held up, cannot take their afternoon coffee, so you all can leave.
In the second half, other matters will be taken up.
We have some liberty too, my lord.
We are taking up 9 first.
9 first.
18708.
18708.
Yes.
Yes, Lordship, I take instruction that actually, if you Lordship come to page number 239.
Yes.
239. Reply. 239.
Yes.
239. The earlier bidding tender notice 2019. There's a point number E, Lordship, that bidder must have the tax audit report, audit balance sheet, and statement of profit and loss account, at least 3
One
financial.
minute. 239. 239 in the item number 9.
Item number 8 refer করছিস তুই।
হ্যাঁ, item 8 হচ্ছে তো।
না 9
9 হচ্ছে। Then Lordship come.
18টা না 19টা কোনটা দেখাচ্ছে?
19টাই দেখাচ্ছে।
19টা।
Come to page number 255.
Yes.
Point number E.
The lead member bidding consortium after the award as signing of the contract agreement shall be obliged
Yes.
to contain
Point number
E.
E. Yes. Bidders must have.
Yes. Tax audit report, audit balance sheet, statement of profit and loss account, at least 3 consecutive financial years. Thereafter, both the member consortium must have tax audit report, audit balance sheet, loan account, 3 consecutive financial year. That actually usually the time period for 3 years we usually followed. That's why in the current we stated at least minimum 3 years required for the GST and the tax trade license. This is my telephonic instruction. In the previous bidding, there's the 3 years. Usually we followed the minimum 3 years mandatory.
And the requirement of having a trade license over here.
Trade license over here, Lordship. If you Lordship permit the applicant that they should participate in the bidding, Lordship. Because trade license is
to say if you
this is my instruction, Lordship, that the trade license as with the 3 years we usually followed. That's why we submitted in the report that the 3 years must be required. There's nothing. Only this usually we followed the 3 years mandatory provision. That's why we impute the 3 years. This is my instruction.
Trade license in the state for a period of 3 years. This is the offending clause according to the petitioner. Now, if you want to do away with it, you have to bring out a corrigendum and get it done. It should be made known to the public at large. Why restrict it to the petitioner?
Actually, we usually followed the
no
3 years.
Actually or anything of that sort. Does this authority have a legal advisor? A proper one to advise them as to what is to be done? Things cannot be done in such a manner. You are state under Article 12.
I understand.
Then what will you do?
Actually, in this agency,
again, actually,
in this agency, there is no legal advisor. This is only for the technical aspect. Advisor is there, Lordship.
And this is going to happen. The authority can take the advice of the state councils who are there.
Lordship.
What is to be done? The court is not going to alter any of the terms and conditions in the notice inviting tender. It is you who have to do it. What will you do?
The Lordship, we extend the time limit and we change the
extend.
Agency.
Yes, the agency is going to extend. The court is not going to extend. What to do? I adjourn the matter. You come up with whatever you've got to say.
Lordship.
But if in the meantime you do not extend and the petitioner loses the opportunity, then something else will happen.
Lordship. I understand, Lordship.
You understand? Make this known to your clients so that they also understand. Understanding should not be limited to you. It should percolate to them also. Yes, what is to be done? Mr. Sengupta, what is to be done? I was not agreeable to enter into the writ petition at all because the scope of judicial review is extremely limited. It is the authority's terms and conditions. The authority is going to take a decision as to 3 years, 6 years, as to whether to have an office here or not to have an office there. It is absolutely their discretion. And I thought it was right. But now the submission that is being made, I have to change my mind. What is to be done? I adjourn the matter.
Lord, if my lord looks at page 100, 18th, they are going to open the technical bid.
If they come up with a corrigendum, all the dates will shift.
Lord, that I completely will not bow down to your lordship, Lord. They should not open the bid till on 18th, keep it on 19th, let them come back with 1 day. They should not open, Lord. 1 day. If they extend the time, I'll participate. But if not, something is done in between, we never know what will happen. Or my lord keeps it on 19th as the first matter, let them not open till 19th. 18th is the date. If my lord feels so, Lord.
Please come. The petition. No, the petitioner challenges certain eligibility conditions mentioned in the notice inviting e-tender floated by the West Bengal Renewable Energy Development Agency. Stop. After hearing the parties, the learned advocate representing the agency submits that the agency would permit, not would, but may permit the petitioner to participate in the tender process, and the agency is agreeable to modify / alter / change the conditions of the tender document. Stop. Next. It appears that the last date for submission of the bids is today. That is 14th August 2025. And the date of opening the bid is 18th August 2025. Stop. As the agency intends to come up with an addendum / corrigendum, accordingly, the agency is restrained from opening the bids that have been submitted by the bidders. Stop. The matter is posted in the list on 19th August 2025. Stop. Learned advocate representing the agency shall come ready with necessary instruction on the adjourned date.
As per the instruction that I submitted, kindly record it, Lordship.
Yes. Unar boktobota upon instruction. Did you file your wakalatnama?
Yes, Lordship.
Lord, item
Toilet, please check. Toilet ache? Please check.
Lord, item
Please
8,
check.
the only difference is that is for solar power pump.
I have not mentioned the
Lord, the
number or the projects.
Two different
nothing.
issue is same, but two different tender. Issue is
Hey,
same.
I have mentioned only tender. The dates are also same.
Dates are
Yes,
same.
all are same. So
All
my
are
is passing
Same
order
order in the other matter also.
as well as.
Please check up.
Same, Lordship.
Yes, the Passover matter. Mr. Chakraborty is there.
But I'm grateful to know.
সঞ্জীব চক্রবর্তী কোথায় গেল আপনার উকিলবাবু কোথায়?
decided that they will not grant any permission to any further law college for next 3 years because of the mushrooming. Not only one thing, 8 and 9 made retained or appear in the same heading, Lord.
Yes, same heading. Same heading.
It's my duty, not only one difference between 8 and 9. 9 I got the work last time, 8 I did not get it.
I have not mentioned whether you got or not.
I make
very
it
well.
clear, Lord.
Your Lordship, before your Lordship.
Cost.
It's mentioned can 1 of one writ petition which is listed today, Your Lordship, but it is there as item number 615, Your Lordship. The can is a very short application of Your Lordship for expunging the name of Union of India, Your Lordship. If Your Lordship can kindly fix the matter at any time, Your Lordship, before Your Lordship rises for the
সকালবেলা মেনশন করলে 600 কত?
It's 15, Your Lordship.
এটাকেও রেখে দিন। Yes. Huh? I didn't get you. Why? Is there any resolution of the bar that the court will not sit?
No, we have a resolution for 3:30.
3:30. So from 2 to 3:30 we will be working. We do not have any other option.
Well, actually, I find your lordship is sitting for the entire recess. That's why.
I keep doing this. And it's for y'all, not for my benefit.
Oh, yes. Lordship, can be permitted to one mention.
Again mentioning.
My lord, exigent circumstances, my lord. This matter, my lord, a contempt matter, my lord. Mr. Pankaj, my lord, bidding, it was, my lord, kept returnable on 24th July 2025. My lord, grave situation, my lord, the demolition has not been completed, but my roof has been leaking because of that demolition. And now, my lord, the matter is
from 21st July. Then what were you doing?
Well,
and this is not the time to mention. Please maintain the decorum of the court.
Well, no, my lord.
No, please do not.
Would your lordship not upgrade one contempt application? Contempt application, upgrade.
Upgrade now. Please excuse.
Monday morning, I have.
No, Monday morning I do not accept this type of. Thursday morning you have to come.
Thursday morning.
Wait, please, your lady.
Well, item number one. Well, I am praying only not today.
Not today.
Or this requires affidavits, pleadings are complete.
Yes, sir. It everything completed.
I need to argue, my lord, on the question of maintainability of the contempt petition in view of non-compliance of Rule 4 and Rule 7 of the Calcutta High Court rules, my lord, pertaining to, my lord, the Contempt of Courts Act. This is not even in, my lord, the proper format. That apart, my lord, I need to, my lord, take your lordship, my lord, through the pleadings, my lord. They are trying to, my lord, amplify, because my lord will remember at the time of disposing of the writ petition, my lord had referred to the fact that this is, my lord, there is some political inspiration behind filing of the instant writ application, and it was recorded by your ladyship that the court will not go into that aspect. Now, my lord, they have filed their reply. It is clear and apparent. They now want, my lord, want to challenge the relocation of the hawkers on Mall Road, my lord, in Darjeeling, by way of filing this contempt application.
My lord, I am also showing, my lord. They are opposition, I am showing.
So, my lord, this is going to take some time.
They are admitting and totally change their stand.
The question of maintainability. So, I need to argue, my lord, on that. It's going to take some time. No, political, it is recorded in her ladyship's order. That is what I am indicating. My lord was pleased to observe.
They are admitting that their construction is going on. And in the writ petition.
Ready, my lord, he can press his case.
Saying only not today, my lord.
My lord will keep it after the vacation, or my lord, any time, my lord, next week, my lord.
Anytime means the contempts are taken up only on Thursdays.
My lord fixes it at 2 o'clock, my lord, go and my lord finish it off then.
Next Thursday, it will not be possible. Is it so very urgent?
There's no urgency, my lord.
Because the prayer is made to shift it after the vacations.
My lord, no, my lord. Urgent, my lord.
There is no urgency because on the last.
I have annexed the photograph. They are completing. They are now plastering everything. They are going.
There was an observation. There was an observation that there will be no high rise not in accordance with law. Now they say this is a beautification project, my lord, because there is a decision adopted to make the Mall area a hawker-free area. So beautification, widening of roads. Beneath that, my lord, there are 2 levels.
Take care of the fact that the hills are just vanishing.
Yes.
So if you raise any high rise over there or any type of construction which should not be there,
that is not even his case. That is not even
the public will suffer if any accident or something takes place. The manner in which landslides and everything are
Mother Nature seems to be very angry.
So do not make her more angry.
No. It is not such a case, my lord. It is a politically motivated one. I'll show it to your ladyship, my lord. Here the allegation is no high rise.
Petitioner, learned advocate for the petitioner seeks accommodation for the day. Stop. List for further consideration. I am thinking to post it after the vacation. Prior to the vacation,
can take my word, my lord. This particular case, my lord.
Before vacation, any
Thursday, nothing, my lord.
As your lordships.
Because I'll take some time.
18th of September.
Lord, they supply me.
18th of September.
Their opposition. They annexed one documents regarding plan that is nothing visible. I kindly direct them to supply a copy.
Write a letter to the advocate on record.
Copy of?
That will be
copy of the so-called. I do not know whether it is a plan or
so-called.
Each page, let your learned friend know about the page. A copy will be supplied.
Page 16, page 17.
All right, you seek for the documents. Please supply the copies if they are illegible.
This is not
seem to be more legible than what I have.
That's why I am not going through this. I make my submission on the basis of this document.
Check up.
Nothing.
The court's copy is also the same. Let us see.
This is not
even their sanction plan.
This is not even German.
The subject matter. They have no sanction plan.
This is not even German.
Point is they have no sanction plan.
Next.
Grateful. But will it be your ladyship's pleasure, my lord, to record, my lord? I have raised a question of maintainability, my lord.
You can always raise it.
Wait.
Next.
Lord, I am for the commission, my lord.
You are for the?
Commission contempt respond number.
Yes.
Lord, though your lordships has been directed to file compliance report, my lord, but my lord, district inspector of school directed to district inspector of school to find out the alternative arrangement and then forward it to the school service commission. The district inspector of school has not, my lord, forwarded the alternative vacancy. So, my lord, we have, my lord,
Lordship, in
returned.
this matter, I am on behalf of the petitioner, Lordship.
Yes.
Lordship, there was a direction to file the affidavit, Lordship. Till that, no, not yet filed the affidavit, Lordship.
Who is to file the affidavit?
My lord,
SSC, Lordship.
School, my lord.
SSC. The SSC council is here. And submission is that the alternative vacancy has not been intimated to the commission.
Lordship.
No, we have, Lordship, I am appearing for the state. We have communicated to them, and the Center School Service has further instructed the DI to issue fresh notice. We have issued fresh notice, and the date is now fixed on 28. Within time has been framed within 28th August.
Within 28th August, what is to be done?
We have issued fresh notice for inviting interested students, teachers to come for with this arrangement of alternative arrangement.
So you want to make this alternative arrangement ready?
Yes.
28th of August is the date.
Within 28, we have asked them to inform us if they are willing to nearby schools.
From whom have you sought information?
School Service, Center School Service Commission asked us to issue fresh notice.
This is the notice, my lord. We have returned that
This
answer.
is my instruction of the DI, Kujvia.
Last two paragraphs.
Since we have already invited, but since we have failed to make alternative, we have informed the matter to School Service Commission, Center School Service Commission. But since they have asked us to give further notice, we
have not rejected, my lord.
Yes, your commission is not in a position to consider the petitioner's transfer for issuance of recommendation.
Then last paragraph.
You are requested to inform the commission. You are requested to inform the commission immediately after such an arrangement is made so as to enable expeditiously. What is to be done? I do not know. When the vacancy will be found out.
My lord, the entire notification is quoted, my lord, in second paragraph, geo-dated 3rd January 2022.
You had please pass on a communication to the petitioner. Let him go through it and come back. The communication made by the chairman, West Bengal Central School Service Commission, dated 8th August 2025, addressed to the District Inspector of Schools, within bracket Secondary Education, Kuch Bihar. Filed in court today is taken on record. Stop. It appears therefrom that the alternate vacancy is yet to be identified. Stop. Learned advocate for the petitioner is directed to come ready with proper instruction on the adjourned date released on 11th September.
Grateful, Lordship. Kindly one in my appearance recorded.
Yes, your appearance
Earlier
will be
occasion,
recorded.
my name is not been recorded, Lordship.
You were not there possibly?
No, Lordship, I have appeared, Lordship.
দেখে নেবেন তো ওনার appearance-টা যাতে থাকে. Next.
Grateful, Lordship.
My lord, may I pray for one kind indulgence? My lord, in this matter, Mr. Rajeshri Basu is appearing on behalf of alleged contempt number 2. But due to his some personal difficulty, he has not able to come to the court today. Well, let it be made not today and taken up on 21st.
You are for the petitioner? Yes.
It's his first time appearing, my lord, though a copy was served upon them.
Actually, this
Prior to the direction passed by the
Just because, my lord, there was a widening of a metal road in Alipur Zilla Parishad, my lord.
Please come. The petitioner alleges violation of the direction passed in the order dated.
30th April 2020.
Let copy first date the order আছে সেটা করে দেবেন. Released on
actually there is some, I think there is some communication from the office of the LR because Mr. Ganguly, my learned senior friend, is also appearing for respondent number, contender number 2.
4th of September.
আরে রাজস্বী বাসুর জন্য টাইম নিচ্ছে, ওকে তো এনগেজ করেছে, ওর একটা বাড়িতে অসুবিধা।
Milods have made it returnable in your
4th of September.
4th of September. Most obliged.
I am for the petitioner. Delivered violation of the Lord's order dated 23rd April 2025.
Yes.
Kindly have a look, page 20.
First day appearance.
First.
Sir, 4th of September, it's returnable. Next.
Well, I am for the
53 and 254, my lord. I am for the petition
compliance report.
Applies.
The meeting
What
has
has
been,
been done?
cabinet meeting has been.
I mean, filing the compliance report has served upon all.
Well, I have gone through this. Yes, your lordship. Kindly once, my lord, for my satisfaction, because of your lordship's, my lord, so much of my lord effort, my lord, today we have here. If your lordship takes up 19th September order of your lordships.
Yes.
19th September 2024.
What is there?
Your lordship has made it clear that from the date of actual appointment in this, my lord, the regular, they will issue the PPO. So far as regards the past service count is concerned, the cabinet will take the decision. Now, if your lordship kindly takes the
Let them
compliance.
show them the writ petition. Where is the prayers?
Wait.
Where is the
please
prayer
wait.
regarding this?
Kindly come to
Please wait.
Paragraph 16.
Para 16 of my compliance report.
Para 16 says so.
Lord, Mr. Banerjee, my lord, is so much of hurry, my lord. May I place?
Yes.
Lord, para 16, what they have stated, the Department of Urban Development and Municipal Affairs, such and such, communicated the Commissioner, Howrah Municipal Corporation, vide inter alia mentioning, Governor is hereby pleased to accord approval for counting of past service only 86 employee initially engaged under CUDP 3. This is of 86, my lord. CUDP 3 we have engaged. Since the respective date of their joining the regular and supernumerary post in Howrah Municipal Corporation.
Done.
The above memo was issued in concurrence with the Finance Department. So, my lord, as of today, they have agreed to count our previous service from the date of our initial appointment under CUPD 3. Is it the stand of the UD, my lord? If that be so, your lordship can dispose it.
I am unable to understand this sentence.
Yes, lord. Kindly.
You engage these people from their initial engagement under CUDP 3, and at the same breath you say that they will, since the respective date of joining the regular supernumerary post. What does this mean? Both are contradictory to each other.
Lord, I will be nowhere.
Not contradictory. My humble submission.
What is it?
This is the in compliance of the essence of the order. Malad, kindly come.
What is the date? Give me the date. Principal Secretary, are you here?
Yes, ma'am. Yes.
Yes, please say what does this line mean, because the court is unable to follow it. Which will be the date from which the service of the petitioners will be counted, whether it is from their engagement under CUDP or the regular posting in the municipal corporation, which is later than the engagement in CUDP.
That is from their joining on the regular post. From the date of their regular post. From date of joining the regular or supernumerary post in the HMC, ma'am.
That means you are not counting the engagement under CUDP 3.
No, ma'am.
Why have you mentioned that it will be counted initially engaged? See, the language is used. Governor is hereby pleased to accord approval for counting of past service of the 86 employees initially engaged under CUDP 3.
This is a scheme.
This is a scheme.
This is a scheme. This was a project.
Yes.
Then, since the respective date of their joining.
That means those people who were engaged under CUDP 3, you will accord the past service. And then where is the question of past service?
Yes.
Only one thing, Madam.
Sir, I am entitled.
Please do not make submission. The principal secretary is there. The court is trying to reason out what it is.
What is the prayer in the?
If the the date of the joining, there was no 1 minute. There is no requirement of getting an order from the governor if you grant this pension from the regular date of joining. Where is the question of this obtaining approval from the governor?
They were joined in they were engaged in the CUDP project that was very temporary and contractual. Later on, it was decided they will be engaged, they will be regularized only once there is a vacancy in the regular or supernumerary post. Whenever there is a vacancy in the regular and supernumerary post, they have been engaged, they have been regularized, their service has been regularized.
What is going to happen? See, had they not been in the CUDP 3, I do not know whether you would have engaged them or regularized them in the regular post or not. That is not the issue. Issue is whether the past service benefit under CUDP 3 you are according or not.
No, it will not be accorded, ma'am.
It will not be accorded. Now you have accorded this benefit to some other employees, and there is finance department's resolution that you will give the benefit from the initial date of joining in the scheme CUDP 3. What will be your answer to this?
No, it has not been approved, ma'am. It has not been approved. Only those people who have been engaged and regularized from the date of joining the regular post, they have been considered. We have considered that. That's what the finance department has also given the consent on that.
So it is your case that you have not given benefit to any of the employees in the CUDP 3 scheme.
Yes. These 86 we have not given.
86 you have not given benefit. No, it's not matter of 86. Why will you give it to the others? And why will you not give it to these 86 people? Why this discrimination?
We don't have any such record, ma'am.
The records are here.
20 numbers admitted position.
There are 20 other employees.
No, these 20 cases never came to us. Never came to us.
Us means who else will it go to? It will go to the department. It cannot go to anybody else.
So it has not gone to us. We only this case came when these were referred to us from the DPPG, and then we made the scrutiny of the case, and that says we regularized those cases only from the date of their joining the regular post.
Right. There are, you please check your records. There are 20 other employees in whose favor you have granted the benefit of the past service when they were engaged under the CUDP.
My lord, department has not given any approval for those 20 people.
How are they getting the pension from the earlier date?
This case didn't come to us.
Maybe you were not there at that point of time, but the records will suggest that this has been done. The petitioners are alleging discrimination, which as a state you cannot do.
Only the petitioners have not come here.
May I just hand over? Additional Chief Secretary has submitted a report before this Honorable Court in connection with this contempt proceeding itself.
When?
This was submitted before your Lordship on 11th of March 2025. Additional Chief Secretary, Government of West Bengal. Kindly see paragraph 10.
What is there? Please read so that we can
I have another copy. If your Lordship.
No, I may have a copy here also.
Your Lordship has to search for
prayer is from the entry in the corporation.
Mr. Banerjee, why are you?
They are dragging it, my lord.
No. What is troubling you? The corporation should not be troubled because the principal secretary is here.
We are also. They are our employees also.
These 20 people, they approached them.
And my lord, they have.
For some reason whatsoever, benefit has been granted to 20 and is denied to 86. Why this discrimination?
I think, my lord, it has been denied. This particular interpretation, if your Lordship once looks at this, paragraph 10, once your Lordship, I will not find that from your Lordship's brief also.
Yes, I can. You read out what is there. Let the others.
The paragraph 10. Paragraph 10. The additional Chief Secretary. What has been sent? What has been approved by the UD as well as the Finance Department? May I read? In conformity thereof.
Yes.
the finance department has also issued fresh EO that is of 19 February 2025. Kindly read on, it's very important, regarding counting of past service in respect of 86 employees, including retired employees, initially engaged under CUDP 3 since the respective date of their joining to the regular super. So, it's the interagnum period since the date of joining to the regular post.
But then are you aware as to whether actually the benefit has been given or not?
That 20 number of employees, yes, it is in respect of hours. This report is in respect of hours.
No, these languages. Who is going to come with? Mr. Banerjee, please do not make any submission.
The languages,
yes,
they are counting our past service since of date of joining of CUDP 3 to the date of our regularization.
Listen,
that
there
is this language.
That is the jugglery of words.
Yes.
Secretary is interpreting in a different way. You are interpreting in a different way. The corporation is interpreting in a different way. Thing is, you actually show me that these 20 people got the benefit from their first date of joining under the CUDP.
Yes, yes.
And you have been denied. So there is discrimination is very apparent. Please show so that the principal secretary also gets to know that this has happened. Which page?
কোন ডকুমেন্টটা বলছিস বল?
দাঁড়া ওরা বলুক, ওরা ডকুমেন্টটা বলুক।
কোন ডকুমেন্টটা বলছিস?
সাপ্লিমেন্টারি।
সাপ্লিমেন্টারি।
This is not the document in the read pretty. Neither in the contempt.
But I'm just this is the document, by virtue of which the Howrah Municipal Corporation accepted service details of employees who are already enjoyed pensionary benefit considering the period of their initial appointment under CUDP 3. These are the list of employees.
Where is it disclosed?
কোন ডকুমেন্টটা বল?
This is the corporation has handed over.
Yes, what is? What is it?
Is it between HMC and DPPG, that document?
Yes, yes, the PPO has been issued. The details of the 20 numbers of employees is being given. Lord, may I just hand it up? Lord, I will just give you.
Show it to your learned friend first. Where is it, Where is this document annexed?
That is not annexed with the read petition or item. Contempt.
This has to come subsequently.
47 and 46. Yes, yes. It's 48, page 48
of which document? Supplementary affidavit?
Supplementary affidavit affirmed on 15 January 2025.
On record is Shobhik Ghosh.
Yes, Shobhik Ghosh.
Yes, page number?
15 January supplementary.
It's 46, 47 and 48. The chart is being
there is a chart.
Yes.
But that is in is the top service details
top
of employees.
Shubir Kumar Pramanik.
No, this is a different chart, possibly. Sri Ajay Bhattacharya is mentioned over here. It's page 76.
Ajay Bhattacharya, yes. These 20 numbers of Ajay Bhattacharya, your lordship takes it up. From the top, your lordship will give details, service details 20. Of the employee who are already enjoyed.
20 number of.
Yes, yes.
There is a chart annexed to the supplementary affidavit. Please check. And the date from which.
And the PPO number, everything.
Initial appointment is 1/2/1986, yes. And they are getting the pensionary benefit from that date, right?
That date, initial appointment.
Yes. Mr. Das, did you get that?
No.
Page 76 of the supplementary affidavit, there is a chart. 76, 77, 78.
The first name is Ajay.
Yes. And see the column number 5, column number 5 at the top.
Employment exchange, newspaper publication, diary harness.
Left hand side, date and mode of initial appointment under CUDP 3. You see 1/2/1986.
Not available in the service file.
Not available in the service file. Scale of pay, such and such, regularization in 2008. And they are getting the benefit from the initial date of joining. See column 12, extreme right. Getting pension considering initial date of joining under CUDP 3.
Yes, PPO number such and such after retirement.
All 20 of them. So why will these people be discriminated? It's not 1 and 2.
And I believe, my lord, these things has not been placed properly before the cabinet.
No. That is not. Date of absorption was 92. Date of initial appointment was 90.
এটা আবার কোন চার্ট
এই একই চার্ট মানে আছে ওইটাই
নয় এটা
দেখেন আমাকে দেখেন
প্রথমটা অজয় ভট্টাচার্য
It must be there in the supplementary affidavit of your record.
I'm seeing from that one.
এটা তোমার
Principal Secretary, sir, there is a supplementary affidavit which has been affirmed on behalf of the petitioners. Right? At page 76, 77 and 78, there is a chart which is prepared by the Howrah Municipal Corporation and it is signed by the Deputy Commissioner and there are several other signatories. If the document is there in front of you, then it will be nice. Otherwise, you please check up. It contains the service details of the employees who are enjoying the pensionary benefit considering their period of initial appointment under CUDP 3. And there are 20 of them, not 1 and 2. And the date of initial appointment is 1986, same as that of the petitioners. If 20 people can be granted this benefit, why will the rest not be granted?
Okay, ma'am.
And my lord, for my regularized, from the date of my regularization, there is
You'll
no
get it
need.
automatically.
It's automatic. My lord, why they have
Obviously.
shown this that this is pending before the cabinet. That's why we waited. And after this, my lord, they are saying that no.
That means cabinet has refused your prayer, but the reason for refusal is not clear.
Even
and
cabinet decision is not also before your lordship. They have communicated something which is not the cabinet decision before your lordship.
How does
I do
this
not
is?
know. না বাবা ক্যাবিনেট ডিসিশন তো দেয়নি হচ্ছে আমি এই বলছি internal communication.
I will like to have an answer from you. There is a document that has been placed in court today.
No.
This is a report which is signed by you, 14th of August, which includes the communication dated 13th of August by the Senior Special Secretary to the Howrah Municipal Corporation.
Then we know what past service they are counting.
Yes, ma'am.
Where is the question of counting past service? See the communication 13th August that you have annexed. The governor is hereby pleased to accord approval for counting of past service. You are not counting past service at all. You are counting from their regular dates of appointment.
Yes,
Had the cabinet meeting was not required to be convened if the regular service pension is required to be given. It is only for counting the past service that the cabinet meeting was required.
When the finance department issued its concurrence, they had written that it is subject to the approval of the cabinet. That's why the proposal was placed to cabinet and it was passed on 12th of August. And it has been confirmed that the counting of the service will be from their engagement in the joining of in the regular post.
That means you are not counting the past service.
Yes, ma'am.
The query of the court is you have granted this benefit to 20 others. The papers are here before the court. Please check up and revert.
Honorable
Maybe you
Court, may
were
kindly
not
like to
there.
appreciate that this never came to us. We are not aware on the how the 20 people given by they have been regularized from the date of their initial joining in the CUDP project.
Right.
Only
That
this
means
case question came when these cases were referred to the DPG and DPG referred to us for our concern. Then we made the scrutiny and then all the case happened, ma'am.
that means the scrutiny was not done properly. Otherwise, this document ought not to have been missed.
We would like to have a look on that, ma'am.
Please do. And
But initial, ma'am, regarding this, your initial order dated 11/10/2003, that we have already complied. There is no non-compliance on that. Whatever you had ordered in that initial these things, ma'am, we have already complied, ma'am.
And 11/7/24 also, my lord. My lord, looks at the order.
sir, if you try to wriggle out, the court is not leaving you. I want a positive answer as to why this discrimination has taken place. I am adjourning the matter for the day. Please come. A report by the Principal Secretary, Government of West Bengal, Department of UD and MA. Signed on 14th August 25, is placed before the court. Stop. It appears therefrom that the prayer of the petitioners for counting their past service from their initial engagement under CUDP 3 has been disapproved. Stop. Learned advocate for the petitioner has drawn attention of the court where counting of past service was accorded in respect of 20 employees from their date of joining under CUDP 3 in the year 1986. Stop. The Principal Secretary, who is virtually present, submits that he was not aware of the earlier grant in respect of the 20 employees. Stop. It appears that the petitioners have been discriminated. Stop. The Principal Secretary is directed to revert with further instruction upon verification of all documents. Next. Released 4th of September. 3 weeks time, it should be good enough for y'all to go through the papers and revert. An updated report shall be placed before this court on the adjourned date. The Principal Secretary is directed to remain virtually present on 4th September. Same order in 254, 253 and 254. And he is virtually present. Please record that.
Virtually actually.
4th September.
I did not. In this matter, your document, please to pass an order on 15th of March 2023 as page 38. There are direction within 3 months. We have communicated the order on 17th of March. Then, there were communication to them, and on 23rd of April 2024, the authority passed an order, and that order also has not followed your lordship's 3 directions. And then, we issued a contempt notice.
What is the direction that is to be complied?
To inspect the subject premises.
Upon receiving this order, your lordship kindly please to find order dated 15th of March 2023, page 38.
Yes.
At page 39, your lordship find the petition is accordingly disposed of by the directing the respondent number 4. being Bidhannagar Municipal Corporation to consider and dispose of the representation dated 3rd August 2022.
Yes, I followed it. Here, what is your submission?
My lord, the recent order, my lord, was passed, my lord, upon hearing all the parties concerned. The lordship would kindly comes to the recent order.
Inspection was conducted.
The inspection was conducted as per my instruction. Thereafter, hearing opportunities were given to both the parties, my lord, including, my lord, the person responsible. Now, my lord, the person responsible, there are two sets. One with having a sanctioned building plan and the other without any building plan. My lord will kindly come.
There are two persons, more than one.
More than two persons.
Oh, more than two persons.
But there are two sets.
All right, two sets.
3 or 4 persons.
All right, yes.
So, my lord, will kindly comes to the effective portion of my recent order, my lord. The last page of the recent order. Meanwhile, the submitted building plans of the private.
Page.
My lord, I have the copy. It is, my lord, page 56.
Page 54 starts finally.
All right, yes.
My lord, the portion that I am relying upon. Meanwhile, and may I say, my lord?
1 minute, I'll check up. Construction building is completed.
My lord, page 54 starts, my lord. During hearing, the petitioner submitted that the illegal and unauthorized last portion. Constructions of the building, multi-story building made by the private respondent and on the Sally landed property. My lord, these are all Sally landed property. My lord, next one I am not reading. My lord, next page, my lord, page 55, you will also find that on the side of the private respondent, they submitted that they never constructed any structure beyond sanctioned building plan from corporation. Other claims of the petitioners were strongly denied by the learned advocate for the private respondent. During hearing, the private respondent, namely Harikishto Bishwas, Uttala Bishwas, and Kishore Bhattacharya, submitted the entire structures. They created structures as per sanctioned building plan. Corporation private respondent produced sanctioned building plans such and such numbers.
Please wait. The page 56 reveals that unauthorized construction has been detected in respect of one set. What steps have you taken?
Now, my lord, with regard to the set that has been
last paragraph, they have stated that within
I have read it. Yes.
My lord, with regard to the persons who have constructed without any sanction plan, the answer to it, my lord, is, my lord, I have, my lord, given one, my lord, copy of the letter, my lord, that has been addressed to the person responsible. It is dated 6th of August. Admittedly, the recent order is dated 22nd of April 2024. There is a delay. I bow down to your lordship to this effect, my lord. Now, my lord, since they have failed to, my lord, demolish their respective unauthorized portion, we have given the notice of eviction to the person responsible on 6th. So, my lord, 2 weeks is required, my lord. The moment the period 6th of August, my lord. There is a delay, my lord.
After filing the contempt application.
My lord, I am not making any submission to that effect.
You cannot make.
My lord, I cannot, my lord. But the moment the limit period of, my lord, the buffer period expires, my lord, we will, my lord, go and proceed with the demolition period, my lord. We are taking our steps, my lord.
When do I adjourn it?
My lord, as your lordship, my lord.
It is for you to.
In that case, I would seek 2 months time because the other procedures are required, my lord, for police assistance.
Yeah.
Kindly direct the concerned police station, my lord, so that there is no, my lord, delay in our part in, my lord, completing the procedural part. Will kindly do that, my lordship.
Yes.
I am leaving this matter. Wrong time. 2024 to 23 or.
Do you have any other mechanism?
No.
No. So you have to depend upon the corporation.
My lord, I am leaving this matter with your lordship.
The later,
and my lord, apart from this, your lordship will find in the report they have stated that I have specifically mentioned in respect of another person, my lord, this page 61. They have stated that in the report, if I read, my lord, your lordship will be astonished that they have seen only a tin shed structure, but this building, in their report does not, my lord, reflect it, my lord. I have mentioned in my lord, letter of complaint, my lord. And my lord, apart from this, the building plan, my lord, in the Sally landed property.
On a perusal of the recent order passed by the Commissioner Bidhannagar Municipal Corporation, dated 22nd April 2024, it appears that unauthorized construction made without sanction plan has been detected.
And they are also admitted as Sally landed property.
Stop. The corporation has issued notice for vacating the unauthorized construction so that the same may be demolished.
Around
Sir.
6th of August.
The corporation seeks time for effecting demolition. Sir. On such submission, hearing of the contempt application stands adjourned till 20th November 20. An affidavit of compliance shall be placed before this court on the adjourned date. The Commissioner, Bidhannagar Police Commissionerate, Commissioner of Police, Bidhannagar Police Commissionerate, is directed to render all necessary help and assistance to the men and agents of the Bidhannagar Municipal Corporation at the time of execution of the order of demolition. Stop. The occupiers occupying the unauthorizedly constructed portion are restrained from interfering with the work of demolition. Which portion you say that Shaliland is mentioned?
Your Lordship, in the report,
Page
Your Lordship, find
55.
that
During hearing, petition submitted illegal and unauthorized construction in the Shali plot of land appertaining to such and such. Alright, Shali land will take care later on. Let the initial demolition take place.
Fine.
I'll see later on.
all right. Deeply obliged, Your Lordship.
এটা পড়ে রইলো কেন? এটা দিয়ে দেওয়ার ছিল তো। এটা কেন রেখে দিয়েছেন? এটা আগেকার মামলায়। Yes, next.
Well, 256, we are appealing to the petitioner.
Yes.
The very first day when the writ petition came up for hearing, my lord, the matter was otherwise not pressed by the learned advocate who was appearing. This was Your Lordship's order itself. In fact, the learned advocate should have said that we are seeking leave to pick up the matter in some other court, before some other appropriate judicial forum. Only that much we want. A modification to that effect, that the proceedings can be taken up before a separate specific judicial forum. Only that much, nothing more than that.
More than a year has passed.
That is true, my lord. I can.
Where is the advocate on record? There is a change in the council. So with the change in the council, the advice has also changed.
Definitely, I cannot say no, but the thing is that the learned advocate who was appearing in this matter, he or she should have said that the proceedings should be taken up by the appropriate.
Provided the client is willing to. Now, if you force this upon your client that you go and file it somewhere else, and that's a different thing.
That is true, but I'll
because I can see the communication of the petitioner wherein it is mentioned requesting the learned advocate to withdraw the matter as non-prosecution. He did not seek any leave
that is,
to file.
I cannot say anything more than what I have submitted before Your Lordship.
I understand.
Only this much. Kindly grant the leave so that the matter can be taken up by in the appropriate forum, because they are insisting that without leave of the Honorable Court, how are you coming up here?
Obviously, you cannot.
That is true. That is true. I cannot.
But then
we have taken
this amounts to modification of an order disposing of or dismissing the writ petition upon specific instruction from the petitioner.
Yes,
now, if there is any change, where is the communication from the petitioner?
Yes, my lord, I'm sorry, I don't have it with me.
It is not only the learned advocates, and this is the reason
I cannot say
I insist upon the communication.
I'll try to mention the matter before the Honorable Court, but it is absolutely with the court to allow or not to allow.
Provided you come up with supporting documents, see, modification in a disposed of matter is usually not allowed.
Now, I can show you some this is a matter with the SEBI. The SEBI authorities have said that in the absence of any order from the Honorable Convocation,
Please come.
No, not
An application for modification of the order dated 23rd July 24, dismissing the writ petition on the written instruction given by the petitioner number 2.
If your lordship permits.
As not pressed.
Oh, I'm sorry.
Has been filed on 19th March 2025 with an application under Section 5 of the Limitation Act. You were submitting something?
My lord, I was just intending to submit before your lordship that there is an order passed by the presiding officer of SEBI, Justice Dinesh Kumar, where it is recorded that firstly, the appellant has challenged the impugned order in the Honorable High Court at Calcutta, and the same has been dismissed as not pressed. Via order dated such and such. He submitted that leave has not been granted by the Honorable Calcutta High Court to file this appeal. This is the point which is coming up and disturbing everything. That is the reason we have come before the lordship.
This point is bound to come up.
Absolute. That is to come. There is no doubt about it. That matter is to come, and that is the whole point which is to be considered. And if your lordship be kind enough to allow that, only then the my clients can save 25 crores.
Stop. In the connecting applications, there has been a change in the learned advocate on record who represented the writ petition when the same stood dismissed as not pressed. In the paragraph, in the application for modification, the petitioner number 2 has averred that due to inadvertence, the learned advocate for the petitioner did not pray for any liberty to file fresh application before the appropriate forum for proper adjudication of the case. Stop. It has been further averred that having lack of proper knowledge of law and its proceedings, the petitioner reposed complete faith on the learned advocate. It has been further averred that the said prayer was not sought for as a bona fide and unintentional mistake on the part of the learned advocate. Stop. From the averments, it appears that from the communication of the petitioner, relying on which the order dismissing the writ petition as not pressed was passed. There was no mention by the petitioner that the petitioners intended to prosecute the matter before any other forum. The petitioners in the application under Section 5 of the Limitation Act has averred that on the advice of the learned advocate newly engaged, the application for modification has been filed along with the application for condonation of delay in approaching the court. Stop. On the date of dismissal of the writ petition, none appeared on behalf of the respondents. Stop. There is nothing on record to suggest that the copy of the writ petition was served upon the respondents or not. The same was filed on 23rd of November 2021 and stood dismissed on written instruction from the petitioner number 2 on 23rd of July 2024. There appears to be enough delay on the part of the petitioners in prosecuting the case in the proper manner. Stop. Paragraph D. Nevertheless, for ends of justice, as the petitioner number 2 has expressed intention to prosecute the matter before a separate forum, the order dated 23rd July 2024 is modified to the extent as mentioned herein below. Stop. Paragraph D. It will be open for the petitioners to prosecute their case before any other competent forum in accordance with law, if so advised, on the self-same cause of action. Stop. The application for modification, along with the application filed under Section 5 of the Limitation Act, stands disposed of.
Refund.
Time for the petitioner.
Time for the respondent.
Yes.
We have been served with a copy of the contempt petition, accordingly filing one affidavit in opposition.
Affidavit in opposition? Where is the affidavit of compliance? Did you comply the order?
No, my lord.
Who is your client?
The Gram Pradhan.
Gram Pradhan.
Panchayat Pradhan.
And you have not complied the court's order.
My lord, there was an order that has been passed in the writ petition.
Yes.
Order was not been served upon us.
Not
They are
served?
Not served.
All right.
My lord can see it is in page 11, my lord, of the contempt petition.
Yes.
The petitioners have failed to show any document that a copy of the writ petition was served upon the Panchayat. The writ petition was also not served. And thereafter, my lord, once the order in the writ came out, my lord, in the year 2006. No. The order was passed, my lord, on 25th of February 2021.
Yes.
And thereafter, this said order was also not served upon me.
Not served upon you. When did you assume office?
I have joined the office, my lord, in 2018. The writ was filed in 2015. At that point of time, the Panchayat Pradhan was some different person. I assumed the office in the year 2018. Till now, I am the Panchayat Pradhan.
2021, the order was passed?
Yes, my lord.
And this order was not communicated to you?
If you see, my lord, it's already recorded in another part, my lord.
Please come to page 16 of the contempt application.
Page
and then 17. There is a postal receipt and a track report.
We have not been served, my lord. There may be an incomplete set has been served upon us.
Incomplete set has been
The
served
contempt
upon.
petition. Because he is the advocate on record, my lord. So whatever documents I have got, this copy I have got.
Pages 16, did you not serve?
Not served. Not there. As far as my copy is concerned, it's not there.
How many contempt matters have you defended earlier? Is this your first contempt matter that you are?
Contempt. This is my first contempt.
Yes. So you are not aware as to how to handle a contempt application. Right. There are documents to suggest that the contempt application was served. Now the opposition will not do. You have to comply with the court's order. When will you comply?
Within 7 to 10 days, my lord.
Again, an inexperienced advocate making a submission.
My lord, maybe 10 days may be given.
Have you read the court's order? What were you supposed to do?
Within 4 months, my lord, I should have complied the court's order, my lord.
What was the court's order?
The petition is accordingly disposed of by directing the Pradhan, Bail Singer such and such, herein to consider the representation made by the petitioner number 1 alleging unauthorized construction strictly in accordance with law within a period of 4 months from the date of communication of this order.
Right.
Yes, my lord.
Now you say you will comply it within 1 week. How will you comply, will you please say? This is not magic. The court granted 4 months because there were reasons to do so.
Yes, my lord. Yes, my lord.
Had the work been completed within one week, the court would not have given you 4 months' time.
I bow down, my lord. I bow down to your lordship.
Have you handled panchayat matters before?
Yes, my lord. Yes, my lord.
Have you?
Yes, my lord.
Are you aware as to what is to be done to comply this court's order?
Yes, my lord.
What is to be done?
This order needs to be served to the Panchayat Pradhan for necessary steps to be taken, my lord.
What are the necessary steps to be taken?
To demolish the unauthorized or illegal constructions. Whatever.
Sorry, sir. You are not aware of the position of law. I'm very sorry to say. You please take help of somebody who is acquainted with these type of matters. Otherwise, your client is going to land up in prison, I tell you. Please take help of somebody who is acquainted to handle these type of matters. And prior to that, please check up the panchayat laws as to how this is to be done.
Grateful.
All right.
Sure, Malad. Grateful. If Malad gives 2 months of time also, then I will.
Now from 1 week you go up to 2 months. Don't look at him.
Because he is taking the Malad necessary instructions from the client.
Your client's instruction will not do. The Pradhan is not in a position to instruct you. I am sure that she does not know the law. It is you who have to advise her.
With deepest respect.
Instructions will go from you to her and not the other way around.
With deepest respect, Malad. With deepest respect.
Got it?
Grateful.
You fly, it's all right. But you should know where and how to open your wings. Learn it first, then fly. The sky is very big and you can fly. Enough space for everybody to fly. But you should learn.
Good.
All right.
Sure, Malad.
Did you file your wakalatnama?
Yes.
You have?
Yes.
Please come. The direction passed by the court has not been complied till date. Stop. Learned advocate representing the Pradhan seeks extension of time for complying the court's order. Stop. In view of such submission, release the contempt application once again on 13th of November. Stop. An affidavit of compliance shall be filed on the adjourned date.
Grateful, Malad.
Grateful to you.
দেখুন এখানে ও চারটে মেনশনিং আছে
Team number 337. 337.
Yes. Yes. Did you, sir?
My lord, I am for the contempt, my lord.
Yes.
My lord, pursuant to my lord direction, my lord, we have conducted the hearing, my lord. We have passed the resent order and we have communicated the order to the SDO. The private respondent he does not possess any property deed in his favor and he has not obtained any building construction plan from the panchayat. We have passed the resent order, my lord. I am tendering unconditional apology, my lord. I am not in court. We have prepared the affidavit also. We have already communicated the resent order to the petitioner, my lord.
All right, I'm adjourning it for this week. Next week you can come.
My lord, next week I can come, my lord.
Achha. Learned advocate representing the contemptor submits upon instruction that the order of the court has been complied with. Stop. In view of such submission, release the matter on 21st August. Stop. Affidavit of compliance shall be prepared and circulated prior to the adjourned date. Affidavit of
I'm grateful.
record.
I'm grateful, my lord.
It was complied with. Not been complied. Let the affidavit come. All right. You go through it and then make submission.
We have passed the resent order and resent order has been communicated.
All right. Next.
I'm grateful.
520. Item number 522.
I am for the applicant lordship. I have tried to contact the other side lordship, but could not lordship. This is a restoration application lordship. Only I'm praying that the matter can be restored lordship.
The matter got dismissed for your fault.
Lordship.
And now you are mentioning citing urgency. Had the matter been urgent, you ought to have been more vigilant. You were not vigilant, so the court is not accepting your prayer. The matter will remain where it is. Call the next one.
I'm appearing on behalf of the petitioner, my lord. It
Yes.
was dismissed for default on 14th of July, my lord.
Yes.
We have filed it on 17th. Time for the matter to be restored, my lord.
Who is the other side?
Appearing for the
He's
respondent.
appearing for the
Only respondent, or are there others?
Lordship, I'm appearing for
India.
all the respondents, Union of India and the other respondents. Lordship. I had a request before Lordship. My lord had directed us to file a report, Lordship. We are a bit
Alright.
behind schedule in that. If 2 more weeks can be granted to us, if your Lordship is restoring the matter,
My lord,
we would place our report, Lordship.
my lord, the interim order we are enjoying, it is going to expire on 29th of August, my lord.
Going to expire. Your writ petition has been dismissed. Going to expire. What does this mean? What remains in the interim order if the writ petition is dismissed? The interim order is subsisting till, was subsisting till 29th August 25 or until further order, whichever is earlier. The earlier order is the order of dismissal. What remains in the interim order? Please come. July recall করবেন ঠিক আছে learned advocate representing the respondents seeks extension of time for filing the report. 4th of July was the time.
Lordship, the difficulty with these respondents, Lordship, the office is in Faridabad. It is now prepared. It is now again gone for waiting, Lordship. I am waiting for the final copy. That is because of the 2 offices. One is in Salt Lake, one is in Faridabad. The communication between them is taking time. Lordship grants us this 2 weeks time. If it's not ready, then Lordship would hear the matter.
On such prayer, time to prepare and circulate the report by the respondent stands extended till 4th September. Stop. It will be open for the petitioners to file exception to the same within a fortnight thereafter. Stop. Liberty to mention the matter for hearing.
I'm grateful.
My lord, the interim order, my lord.
The interim order has expired. Let us see what can be done. Now I am not reimposing the interim order.
My lord, if my lord is not willing to extend the interim order, my lord, they might not allow us to continue our business.
Yes.
They have already given a banned order, my lord. We are protected by your lordship's order.
You were protected. Now you are without a protection.
My lord, kindly extend it.
What is the respondents trying to do with these petitioners?
There's a connected matter which is already running in your lordship's list.
Right.
After this matter has been,
And that is still alive.
that is still alive. Lordship.
Yes.
My instructions to the authorities are that as long as that is alive, not to proceed for now, because they have filed a restoration application.
All right.
Whether any step is being taken, was my instructions that they're not taking any step.
They have not
But
taken.
lordship,
Please
they
come.
have not renewed, my lord.
The respondents have not yet taken any coercive step against the petitioner. Stop. Accordingly, the interim order, which was initially granted on, please check the date, is reimposed. And the same stands extended till 19th of December 2025 or until further order, whichever is earlier. Liberty is there to mention they are enjoying interim order. It will be your responsibility to get the matter heard. Otherwise, the interim order will go on extending.
I understand, Lordship. I'll circulate the report and mention the matter.
Please do.
Lordship.
Next.
Well, it's my application, my lord.
Yes.
For expunging the name of the defendant, respondent number 6, my lord. That is the Union of India, my lord. My lord, there is no prayer against the Union of India, my lord. And there has been an instruction from the Union of India to delete the name, my lord.
You are for the petitioner?
I am for the respondent, my lord.
You are for the respondent?
My lord.
You have filed an application seeking expunging the one of the respondents.
My lord.
Where is the petitioner?
My lord, we have informed them over telephone as well as we have served
How are you aggrieved if the Union of India remains over there?
My lord, we are not agreed, my lord, but as we are a government company, my lord.
Yes, government
Like-
company.
Yes.
HPCL.
HPCL, my lord.
Right?
The Union of India has given us a letter, my lord,
Yes.
which is at page 13, my lord. My lord, may kindly see, my lord, where they have said where no prayer has been made in any writ petition.
Now it is for the petitioner who to implead as party as respondents. Who are you to say? And you are not for the Union of India. You are for HPCL.
My lord.
You want Union of India's name to be deleted?
Directions actually from the Union of India to the to HPCL. That's
Sir, there may be a lot of directions. You should know as to how to proceed.
my lord.
Then, what type of an application is this? Please come. This application has been filed by the respondent numbers 1, 2, and 5 in the writ petition. Stop. The applicants are the Hindustan Petroleum Corporation Limited. Stop. Prayer has been made to expunge the respondent number
6, my lord.
6 from the array of parties. Stop. The respondent number 6 is the Union of India. Stop. It is very elementary that the carriage of proceedings always lies with the petitioner. Stop. It is for the petitioner to decide as to who to be impleaded as party respondents in a writ petition. Stop. It is not for one of the respondents to choose as to who to be expunged from the array of respondents. Stop. The application appears to be absolutely misconceived. Stop. The same is accordingly dismissed. First time কিছু আছে? দেখুন।
Lordship, am for the petitioner in this matter. Lordship, this is a new contempt application arising out of the order dated 17 January 2024 passed in WPA number 237.
28 August তো হয়ে গেছে বোধহয় আগের দিন। হ্যাঁ, তাহলে পরের দিন করে দিন। 4th of September. Serve.
Obliged, Lordship.
Nobody is there.
Lordship's kind indulgence to mention item 44 of the day's list.
Yes.
And it is that matter, my lord, where the petitioner is supplying, my lord, cooked food diet to the railways hospital. Now, my lord, during the pendency, my lord, they have issued the notice of termination on 8th, my lord. It is that matter, if a lordship would recollect, they have, my lord, learned advocate appearing for the railways have submitted on instruction that they are ready and willing to pay the amount of 70 lakhs. Despite such submission, my lord, they have issued the notice of termination. My lord.
Who is to pay to whom?
My lord, the respondent railways authority is to pay to the petitioner the sum of 70 lakhs, my lord, on lieu of, my lord, cooked food diet supply, my lord.
All right.
So, my lord,
So with the payment made, the writ petition will be over.
If the payment is made, my lord, the claim of the petitioner will, my lord, suffice, my lord.
44. Who is your other side?
My lord, Mr. Dibbojyoti Dev, my lord, if your lordship, my lord, allows my mentioning, I shall, my lord, intimate
No,
my.
Friday payment of dues are heading at the 11. Give notice. Next Friday it will appear.
Some preference.
21st. All matters will be taken up. Don't worry. Under the heading payment of dues. Intimate your other side.
Item number 636, my lord, on new content application, my lord.
636. All right, serve.
My lord, 630. My lord, 630 new application.
Returnable, lord.
624. First time.
630, my lord.
622, my lord.
06.
See, today there is 330.
No, my lord, kindly 630 kindly. take it out.
Mirror 621.
First time, my lord.
Mirror 621 also for the first time. Mirror subject. to
আরে
proceed.
দেখে দিন তো দেখি সিরিয়ালি ডাকুন তাহলে এই ঘাড়ের উপরে উঠে যাবে
No, no, no. Mirror, I am appearing for the bill.
সার্ভ 6 আছে মানে যে নেই বাদে
Lord, I am for the applicant, 622.
সার্ভ
DPO.
This is the first time, madam.
অলরাইট সার্ভ
On a contempt application, first time.
My lord, I am for the petitioner, my lord.
Have to serve notice.
627.
I am for the petitioner, first time.
626 you are there
627, first time.
all right 626 27
First time, my lord.
yes
28.
all right
659.
Mirror, I am appearing for the petitioner for the first time. Mirror.
630.
My lord, the first time.
631.
Appearance to the appearance to the.
632. 633. 633.
634
634. 635. 636.
I am for the petitioner.
all right
Well, item 618 is called well, item 616.
no no 618 will not be called
Restoration application.
no
In one matter, item number 391, my lord. My lord, I want to file a supplementary affidavit, my lord, for incorporating a party contempt, my lord. My lord, the matter pertains to a unauthorized construction, my lord. The Pradhan inspector and their
supplementary affidavit in a contempt matter you prepare and solve we'll see when the matter is taken up
yes, my lord. I have affirmed the affidavit, my lord.
serve